activity, violation of the Georgia Controlled Substances Act, 3 counts, possession of a firearm during the commission of a felony, and possession of a machine gun. Do you understand that?
Yes.
All right. And do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you will continue to receive a jury trial?
Yes.
All right. And have you received this waiver of rights form that I hold in my hand from your attorney and reviewed it with your attorney?
Yes.
All right. And is this your signature on the bottom of this form?
Yes.
Have you had enough time to speak with your attorneys, Mr. Steele and Mr. Adams, about all of the facts and circumstances known to you regarding the charges in Indictment 22-SC-183572, including any potential defenses?
Yes.
Do you need additional time to discuss this case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Mr. Steele and Mr. Adams, do you, on behalf of Mr. Williams, waive a
So a
formal
woman,
reading
so
of
a
this
woman
indictment?
can be 300.
Yes, Your Honor. You do.
And do you, Mr. Williams, waive any and all defects in this indictment, including any with respect to your name?
You do.
Yes.
Have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorneys know of any outstanding warrants related to these charges?
Any what?
Outstanding warrants related to any of the charges in the indictment?
No.
No.
I don't believe so either, Your Honor.
Okay. And I'm unaware of any as well, Your Honor.
I am as well.
Thank you. Have your attorneys advised you of the minimum and maximum sentence for each of the crimes that you are charged with?
Yes.
And each of the charges that you are pleading guilty to?
Yes.
All right. Your Honor, with respect to the charges that Mr. Williams faces, count 1 carries a minimum charge of 5 years and a maximum charge of 20 years in prison or up to a $25,000 fine or both.
Isn't it a $15,000 fine, because wasn't it the version of the statute in effect at the time, or was that the same for RICO? Was RICO 25?
Yes, RICO was 25.
All right. Thank you.
You're welcome. Count 56 carries a minimum sentence of 5 years in prison, a maximum of 20 years in prison, consecutive to any other sentence, with a fine of $10,000 to $15,000, or both.
Okay.
Count 57 carries a minimum sentence of 5 years in prison and a maximum sentence of 20 years in prison. Count 58 carries a minimum sentence of 1 and a maximum sentence of 10 years in prison. Count 59 carries a sentence range of 5 to 30 years in prison. Count 60 carries a sentence range.
Slow down just a second. All right, and that's for the amount of that drug that was found on 59, 5 to 30?
That's as a result of the charge itself, I believe, with intent to distribute.
I think that 59, Your Honor, is simple possession of cocaine. I have to look at the indictment to be sure.
I think that's 60.
Okay.
Let me look.
Okay.
And Your Honor,
59 is codeine.
Yes.
And 60 is cocaine.
Yes.
Oh.
Your Honor, it is with the intent to distribute, so my reading of the statute is that it carries the range of 5 to 30.
Okay.
And Your Honor, also, as I have the indictment in my hand from Ms. Roster, may I pass it to counsel for Mr. Williams?
Yes.
Thank you. Your Honor, with the court's permission, I'll permit time
Go
for
ahead.
them to. Okay. Count 60 carries a range of 1 to 5 years in prison. Count 61 carries a mandatory 5 years consecutive to the underlying felony. Count 62 carries a sentence of 10 years consecutive for a total maximum exposure of 120 years in prison.
All right.
Were you aware of that, Mr. Williams?
Yes.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or the Board of Pardons and Paroles, and that if you are sentenced to confinement in the Georgia Department of Corrections, no one can guarantee parole?
You can say yes.
Well,
She asked you, do you understand that no
Oh,
one can
yes,
guarantee
ma'am.
parole?
Your Honor, may I allow Mr. Williams time to finish signing the indictment?
Okay.
Y'all coming up here to the podium.
Your Honor, with permission, may I approach with a member of Mr. Williams' team?
You may.
Thank you.
I don't know what's gonna be the verdict of this shit though. You must be about to beg the judge and let all the charges fall. Epic.
Mr. Williams, do you understand that this is a non-negotiated plea of guilty, and that since your guilty plea is a blind plea or a non-negotiated plea, the state is making a recommendation of sentencing to the court, notwithstanding the fact that this is a blind plea? You understand that, Mr. Williams?
Yes.
Okay. And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And, Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation, subject to the special requirements of 1615 for the gang statute.
All right, and do you want to break down for me what your recommended sentence on each count is?
Yes, Your Honor. The state is recommending on count 1, 5 years to serve. Count 56, 20 years to serve consecutively to count 1. Count 57, 5 years of probation to serve consecutively to count 56. Count 58, 10 years of probation to serve concurrently with count 57. Count 59, 5 years of probation to serve concurrently with count 57 and 58. Count 60, 5 years.
Ready to master League of Legends? Get everything you need with Face Check. Use real-time stats.
Consecutive to count 57. And count 62, 10 years of probation consecutive to count 61.
All right, thank you.
Mr. Williams, did you discuss the state's previous offer with your attorneys?
Yes.
Okay.
All right, and so we're all clear that we're talking about the same thing. Can you put what the state's previous offer was on the record for me, please?
I can, Your Honor.
Thank you.
The state's previous offer was a total of 43 years with 20 years, 5 years to serve on count 56, commuted to time served, followed by 15 years on probation. On count 58, the sentence was 10 years to serve in the Georgia Department of Corrections, consecutive to count 56. Count 59 was 3 years to serve in the Georgia Department of Corrections, consecutive to counts 56 and 58. Count 60 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, and 59. Count 61 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, 59, and 60.
Was that the entirety of what the sentence was?
No, Your Honor.
I mean, I know there
reading.
were special conditions, so y'all were going to null pros what?
Yes,
1
yes.
and 62?
Yes, as part of the recommended sentence, in exchange for the defendant agreeing to the special conditions that we asked the court to impose, the state was willing to null pros count 1, count 57, and count 62.
Okay. And then all of that consecutive to the probation, that was going to be what we call backloaded, and what were y'all proposing with regard to that, since it was to follow the probated sentence?
The total sentence was 43 years to serve, with the first 5 years in prison commuted to time served, followed by 15 years on probation, followed by 23 years in prison, which would have been served in confinement, except that if defendant had complied with the special conditions of probation imposed as part of this sentence, the backloaded portion of defendant's sentence would have been commuted. However, should defendant had violated any special condition of probation within the first 15 years of his sentence, his probated sentence would have immediately been revoked, and he would have been required to serve the entire remainder of his sentence confined to the Georgia Department of Corrections.
All right, so as long as he had successfully completed his 15 years of probation, the 23 years that was going to follow it was going to be commuted to time served as long as his probation was successful. Is that right?
Yes, Your Honor.
Okay.
And the special, would the court like for us to?
No, I was really more interested in the length of sentence and what y'all had. I mean, I know you didn't reach agreement, but y'all, that's what the last offer had been, with, of course, a bunch of special conditions, which I guess is where the hang-up is. I don't know.
Right. Defendant did not want to agree to the special conditions.
All right. Is that basically your understanding too, Mr.
Yes, Your Honor.
Steele
It
and
would have
Mr.
been,
Adams.
yes, Your Honor, Mr. Williams would have been released today for 15 years on probation. If he successfully completes that probation, then he would not have to go to custody. If he did not, he'd face probation revocation as well as 23 years, as the court said, backloaded in the Georgia prison system. But we could not come to terms on all the conditions that the district attorney was insisting upon.
Okay. All right. Thank you. Go ahead, Ms. Love.
Okay. And Mr. Williams, were you aware of that previous offer as well as all of the requirements that that offer would have entailed?
Yes.
Okay. And had you had enough time to discuss that particular offer with your attorneys?
Yes.
All right.
The previous one?
The previous
Yes.
offer.
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment? Do you understand that, Mr. Williams?
Yes.
Do you understand that if you enter into a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
I'm not on probation.
Okay, so you're not on
If
probation.
you were on probation,
Yes.
but if you're not, then it doesn't matter.
Okay. Do you understand that if you are placed on probation of any kind by this court, you cannot violate any criminal laws of any governmental unit or any special conditions of probations without being subject to revocation for the balance of the sentence the court imposes?
Yes, I know.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, and the Department of Corrections or Board of Pardons and Paroles, and that no one can guarantee parole no matter what anyone has told you? Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that, Mr. Williams?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or if you use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of up to 1 to 15 years in prison?
Yes.
Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to that if you continued at trial, rather, you would continue to have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand all of those things?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury. Do you understand that?
Yes.
The right to remain silent and not incriminate yourself?
Yes.
The right to confront witnesses against you?
Yes.
The right to continued assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney the continued trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proven beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial. Do you
Yes.
understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Well, Your Honor, may I interject?
You may.
Your Honor, on count 1, which is the racketeering conspiracy count, Mr. Williams is tendering a plea under nolo contendere. As to count 56, which is participation in a criminal street gang activity as being a leader or a supervisor or organizer, Mr. Williams is also tendering a plea to this honorable court under nolo contendere. The balance of the counts, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes.
Sure.
Your Honor, the state asked that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right. I'm going to permit a NOLO plea as to counts 1 and 56.
All right. Mr. Williams, as to count 57, participation in criminal street gang activity, how do you plead?
I plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 60, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony, how do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, how do you plead?
Nolo.
As to count 56, participation in criminal street gang activity under the leadership charge, how do you plead?
Nolo.
All right.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
Guilty.
Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
All right. Are your guilty pleas and your nolo pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today's date for a felony charge, and 12 months from today's date you don't have a misdemeanor charge, but to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Your Honor, also, do you...
You have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw the guilty plea, which does not mean it would be granted, but that's the time period, okay?
What's the direct appeal?
Well, you can talk to your attorneys more about it, but it would be up to one of the, like the Court of Appeals, I think is where this one would go. It's just the time periods.
And, Your Honor, the state, in addition to the sentence we are asking that the court to impose,
Okay.
we would also be asking the court to require or to forfeit, have defendant forfeit all of the property that has been seized and that is currently being held, that was found or recovered or taken from his home after it was searched on May 9th.
Do you have any kind of list of what that property is? I mean, I'm not familiar with what was seized.
And, Your Honor, we're not agreeing.
Oh, I mean, I assume y'all aren't agreeing to anything.
We're not agreeing to that.
You would present it as a negotiated plea.
We're not. But we do have a list of the property items.
Do you have it available right now?
Yes. Actually, would the court permit us to send it electronically? Because
sure, that's fine. And then if that is not imposed as a condition, is it just get litigated as like any forfeiture matter?
Yeah,
it would be litigated later on, yes.
It's a civil separate filing
Okay.
in this court. It's not related to the criminal
All right.
case. It's related case, but it's unrelated.
Understood.
And we are sending that to Your Honor.
Thank you.
At this time. And as it relates to the conditions of a conviction under 1615-4, Your Honor, we would ask, or as part of the sentence, defendant would be required to adhere to the requirements, the sentencing requirements of the gang statute, which at least in part require that he not associate with any gang members whatsoever. And I can read the rest of that into the record if the court requires, or I can continue with the factual basis.
All right. And let me ask you, because I know that at least while y'all were negotiating, one of the things that I guess was being negotiated was some exception for, I think, somebody that is contractually obligated on his record label. Is that something that the state would still be in agreement to?
No, Your Honor.
Okay. All right. Go ahead.
All right. Your Honor, as part of the requirements of 1615-4,
yes,
defendant would, one moment, Your Honor. Under 1615-4, in addition to any other penalty provided by the code section, all sentences imposed under the code section shall require as a special condition of the sentence that the person sentenced shall not knowingly
Slow down just a tad, because there's a court reporter taking it down. And when we start reading, we read really fast. So go ahead.
This code section shall require as a special condition of the sentence that the person sentenced shall not knowingly have contact of any kind or character with any other member or associate of a criminal street gang, shall not participate in any criminal gang activity, and in cases involving a victim, shall not knowingly have contact of any kind or character with any such victim or any member of any such victim's family or household. So that is, and we've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case has been tried and would continue to be tried until the state completed its case in chief, the evidence has shown that the defendant, throughout the time between 2013 to 2022, conspired with both indicted and unindicted co-conspirators to participate in the enterprise known as Young Slime Life, or YSL, through a pattern of racketeering activity. Throughout that time, multiple conspirators, both indicted and unindicted, and including the defendant, have committed overt acts intended to further the enterprise itself. With regard to the defendant, as far back, the evidence has shown, as 2013, the defendant, along with other YSL founding members, Walter Murphy, for one, committed an aggravated assault and armed robbery against Derek Dotson. The court has heard evidence of that presented through Adrian Bean, who was a co-conspirator in that particular act. The armed robbery of an Archillian Bennett back in 2013. As alleged in the indictment, defendant and unindicted and indicted co-conspirators committed acts to further YSL that included drug sales, aggravated assault, and murder. They used and furthered, rather, this conspiracy by using social media posts and music to assert the violent nature of and the dominance of Young Slime Life, which is also known as YSL. The defendant is charged with being a leader of the gang YSL, and evidence has been presented by accomplices and co-founders of YSL, Trontavia Stevens and Walter Murphy, and evidence would have been presented in the words of the defendant himself, that the defendant, as shown by some of his own social media postings, was the founder, one of the founders of YSL, along with Mr. Stevens and Mr. Murphy. YSL formed, according to the evidence that has come out in this trial, in 2012, 2013, under the former version of the name of the gang called Rock Crew or Raised on Cleveland. The court has heard evidence of the 2014 and 2015 incidents that have involved conflicts between YSL members and IF gang members that included someone shooting the window of Mr. Williams' car and armed individuals rushing outside during shootings at Club Crucial to ensure Mr. Williams' safety, shootings at a place called the Dugout where armed individuals rushed to ensure Mr. Williams' safety, shootings at Mr. Kelvin Watts committed by members of YSL, communication with members of YSL after those incidents, and ultimately the murder of Donovan Thomas at the hands of members of YSL. The evidence has shown and will show that on January 10th of 2015, members of YSL drove a car rented by the defendant, a gray Infiniti, and drove past Mr. Thomas as he stood outside of a barber shop congregating with friends, and unloaded an array of bullets on Mr. Thomas, hitting him, his Chevrolet Tahoe, and two other persons in the process. Mr. Thomas died from those bullets. Phone records show that communication was held between Mr. Williams, Mr. Kelvin Treadwell, Mr. Demise McMullen, corroborating accomplice testimony that has been presented in this courtroom regarding what happened, who committed the murder, and what happened to the guns and the vehicles that were used in the murder. After the murder of Donovan Thomas Jr., the members of YSL responsible for the murder and members of YSL who were not responsible for the murder congregated at Mr. Williams' condominium called the Sky House, and they all made plans and later either drove or flew down to Miami. Prior factual acknowledgments by members of YSL include that Mr. Williams gave each of the persons who accompanied him to Miami money to lay low as they left the city following the murder of Mr. Thomas. The evidence has shown the ensuing conflict that occurred after.
Make your mark as an expert. Stand out.
Shootings at Mr. Rashawn Bennett's home, shootings at Mr. Darren Mills' mother's home, and I said Mr. Rashawn Bennett's mother's home. Shootings unrelated to the conflict with members of Gang, of a Lil Wayne tour bus. That shooting followed the confronting by Atlanta Police Department of members of YSL that drove to the compound where Lil Wayne was making an appearance, and who drove there with the intent to disrupt and cause harm and to shoot up Lil Wayne's tour bus. Lil Wayne was another artist with whom Mr. Williams was having conflict, according to the testimony that had been presented. Mr. Williams had come out at that time with a mixtape that carried the name of an album that Mr. Carter was set to release and was not able to because his label would not allow that to happen. That caused a contractual or the threat of a lawsuit. It caused Mr. Williams angst. He posted about it. He said derogatory things about the persons who were threatening him with the lawsuit. And as a result, he had to rename his mixtape to something different than what he initially intended. The person who ultimately was convicted of shooting that tour bus up, Jimmy Winfrey, is a person that I believe that recordings have come in regarding jail phone calls, rather, from Mr. Winfrey and members of YSL regarding communication about getting a lawyer. Following the shootings that occurred in 2015, music, social media postings, and other overt acts were committed by Mr. Williams and other members of YSL, taunting members of groups that they considered opposition to YSL, posting of threats of violence by members of YSL against those people. Specifically, the music, Your Honor, contained lyrics such as the following: I rep my life for real, for slimes, you know I kill. I shoot at your mammy, need to stand down. I up my stamina, take it to trial, get an appeal, take it to trial, pay for that casket, that's just if we whack 'em. YSL slimy and shady, watch me whack that bitch, pop 'em like a cyst, Glock with the assist. It also consisted of a song wherein Mr. Williams sang or rapped the lyrics, hey, this is that slime shit, that YSL shit, killing 12 shit, fuck a jail shit. I'm in the VIP, I got the pistol on my hip, fuck the police. You praying that you live, I'm praying that I hit, this that slime shit. 100 rounds in a Tahoe, I'm prepared to take them down. Got banana clips for all these ends acting monkey. This is that slime shit. This is that mob shit. Fuck the judge, YSL. This that mob life.
Can't believe they all this shit out. And they're going to let the judge make the decision. Kind of blind.
Defendant Williams released a video on YouTube of a song wherein he states, I shot at his mommy, now he no longer mentions me. Act like you want war, and they gonna smoke you like a blunt. Another song, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about a cop. I'm just telling you how it is. I done did the robbing. I done did the jacking. Now I'm full rapping. Gave the lawyer close to $2 million. He handles all the killing. We don't speak about shit on wax. It's all my business. We know to kill the biggest cats of all kittens. In another song, I was on Cleveland, stuck like a magnet, bitch ass N-word, pay for that casket, that's just if we whack 'em. In yet another song, Defendant Williams raps, red just like Elmo, but I never fucking giggle, YSL won't fold. Pick his ass off from the balcony, wipe an end's nose. I'm going to F for the cash, then she getting robbed by Tick, a reference to Trontavia Stevens. All I ever wanted was the money, put your hands in the air if you dare. F and N, put him in a wheelchair. And even later on, Mr. Williams, and I believe that this was in 2019, made a post to YFN Lucci or Rayshawn Bennett. If I didn't like what you do for your mother and kids, I would have been killed you. And in yet another song entitled Anybody, Defendant Williams stated, I never killed anybody, but I got something to do with that body. I got the streets on my back, carry it like I'm moving a body. I told them to shoot 100 rounds like he trying to movie the body. Ready for war like I'm Russia. I get all types of cash. I'm a general. As Mr. Williams' prominence in the music industry rose, his ascension within or in leadership in the gang YSL became more apparent as he rapped and talked about the crimes that YSL co-conspirators and members committed and how he got away with robberies. With respect to the Donovan Thomas murder, the court has heard evidence through phone records that within 6 minutes of the shooting of Donovan Thomas Jr., a phone call was made from Demise McMullen's cell phone to Defendant Williams' phone, and then immediately after that call, Mr. Williams calls his sister Dora Greer and then calls Kelvin Treadwell. There is then a series of calls between Dora Greer and Treadwell, and then Treadwell calls Demise McMullen or Nard. All of those calls happen within 15 minutes of the 911 call. And as I have stated before, the court has heard accomplice prior inconsistent statements about who committed the murder itself and what happened afterwards. The conflict between YSL and members of IF Gang continued into 2019, wherein Mr. Williams raps the lyrics that I referred to earlier. In May 2019, a YSL member shot multiple times at a vehicle owned by Rayshawn Bennett. a black and red Mercedes-Benz G-Wagon that at the time was being driven by a Milton Howard Jr. It was after that incident, later in August 2019, that Defendant Williams posted on his page the language, YFN, if I ain't like what you do for your mother and kids, I would have been killed you. The post was then deleted from his account. Through text messages of a co-conspirator, Marquavius Huey, there was communication between Mr. Huey and Mr. Williams both in January and in September of 2020. On January 19th, 2020, Mr. Williams sent a flyer to Marquavius Huey with the performance location of Rayshawn Bennett, or YFN Lucci, and when he sent that, he sent it with the message, "Handle that tonight, SLAT, S-L-A-T-T. Mr. Huey responded, SLAT, S-L-A-T-T. On September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of YFN Lucci, and Mr. Williams responded, SLATTY, that is S-L-A-T-T-Y, handle, and stay very low. Mr. Huey responded, SLAT, and for show, F-A-S-H-O. I've been out the way, and appreciate you for everything, my brother. Never about money with me. I'm built on loyalty. Mr. Williams responded, SLAT, handle that. I got you. Through text messages and on a separate occasion, Mr. Huey said and conveyed to Mr. Williams that he would sit down for any one of them, and I believe that to be a reference of going to jail. When Mr. Bennett was not killed in 2022, Jaden Myrick sought permission from Defendant Williams to stay.
Ready to hear about our Heavenly Father's plan for you?
I think it is time.
Yeah, these motherfuckers ain't got no act right. The show taking her time reading all this nigga shit out. About 3 murders in 100 years on them.
and waited at a red light.
My fault, y'all.
Later, Mr. Stillwell, Mr. Nichols, Mr. Garlington, and Mr. Farley were all charged with the murder. That is one of the acts that we are still and would anticipate the court seeing the evidence of during the course of this trial. After grand jury warrants were issued after this indictment for Mr. Williams and 27 other co-conspirators, following searches of phones, wiretaps, and other information that led police to understand the role that Mr. Williams played in the YSL street gang and enterprise. Mr. Williams' home, he was arrested at his home and a search warrant was executed inside his home. While at his home, a sale amounts of illegal narcotics, including those that he is charged with in this indictment, was found. Also found was the machine gun with which the defendant has been charged in this indictment. The gun had a switch. The narcotics included marijuana, codeine, and cocaine, and inside the home were also other guns besides the guns with a switch. The items were seized, and again, Mr. Williams was subsequently arrested, along with other YSL members at Mr. Williams' home. Your Honor, that is the evidence that I believe has been shown throughout the course of this trial and that the state would continue to show. There are several messages between Mr. Huey and Mr. Williams inside the cell phone one of the cell phones that were recovered from Mr. Huey. Besides the messages.
I hate you, you fucking orange pumpkin. You just costed me one of the...
Tells Mr. Williams he has a new number. Mr. Huey asked Mr. Williams, hey, my brother, I'm fucked up. You ain't got nobody I can pull up on and have something in my pocket. Mr. Williams responds, slat, let me call BEO. Mr. Huey responding, slat, I need you, my brother. Mr. Huey saying, asking whether or not a lawyer was going to go and talk to another YSL associate, asking Mr. Williams to send him some money to pay his lawyer off. Mr. Williams asking Mr. Huey, who had been accused of armed robbery, what did he want? Mr. Huey responded with a number. Mr. Williams responded, slat. After Mr. Williams stole a star ring from one of the victims in the indictment, he asked Mr. Williams, do you have a star ring? Mr. Williams said, yes. Mr. Huey said, slat, you can't cash at me $500 so I can make a payment to my lawyer. Mr. Williams responded, slat. Mr. Huey sent him his phone number. Mr. Williams assured him through his responses, slat, that he would take care of them. Throughout Mr. Huey's phone, you see messages of this nature between Mr. Huey and Mr. Williams. The court, again, will hear that as this trial continues. The recommendation that the state previously made prior to us reaching this point was made with the hope that Mr. Williams would agree to certain special conditions of probation that we asked him to adhere to, and that he would take ownership and responsibility for being the leader of YSL. Given that those negotiations have broken down, we are asking that the court sentence Mr. Williams as we have asked earlier, And prior to the court imposing a sentence, we would ask that Ms. Shawana Edmonds, who is the mother of Mr. Thomas, be allowed an opportunity to make an impact statement. And that is all that we have, unless the court has questions.
And
Okay, well,
right
given
there don't
that,
sound good, I'm telling you.
Mr. Williams is not charged with the murder of Mr. Thomas, I don't think that is applicable here.
I checked on that, Your Honor, with respect to count 1. As a co-conspirator, Mr. Williams is responsible for all of the acts of the other co-conspirators, the overt acts. The overt act of the murder of Donovan Thomas is one of those acts.
I know, and this trial is not complete, and so y'all have not yet proven that. Not to mention that he dismissed the murder charge against one of the co-defendants who already fled. So,
not for that case, Your Honor. That was that was Mr. Drink.
okay.
We have not dismissed any.
All right. Well, if there is a conviction on the RICO or murder count following the close of this trial, that would be the appropriate time for the victim impact statement to be made. All right, Mr. Steele or Mr. Adams, does the defense want to put anything on the record? Obviously, you need to make a recommendation.
Yes, Your Honor.
Go ahead.
Many of the statements made by the prosecutor we vehemently disagree with. The prosecutor misstated many pieces of evidence and then took liberty that that is the state's theory. Mr. Williams has tendered a nolo contendere plea to the RICO conspiracy count. And in that count, there are several overt acts. And the first one, Your Honor, deals with a traffic stop. It's on September 9th of 2013. And I won't go through every one because it might take a long time. But just for completeness for this, the court knows, Mr. Williams is driving a car. There is a dash cam video of the stop. The officer who testified at the trial 11 years later, the case was, a gun was found under the passenger seat. Mr. Williams is not tied to the gun. He's not convicted of that. And the dash cam video that the officer said would have picked up sound as well as definitely video was never turned over to us, supposedly lost. Could not explain the loss. The armed robbery in another overt act of Mr. Dodson, D-O-D-S-O-N, has the following information. The state only, because we haven't called witnesses yet. So the state put up a man who said nothing except, I don't recall. And then they put in his prior recorded jail calls. That man was taken, his name was Mr. Bean, B-E-A-N. He was taken to Grady Hospital, and he was spoken with by a detective. The state vehemently accused me of lying to the jury, that the man never went, Mr. Bean was never taken to Grady Hospital, and that somehow I planted on him to say something on a recording where he said, the reason I implicated Jeffrey Williams is because the police told me that it would be easier for me. Then I had to go through the CAD reports and show that Mr. Bean was in fact taken to Grady Hospital, and Mr. Bean on recording told Detective Quinn, who of course told the truth. Yes, when I spoke to the detective previously, I did lie. Then what the state doesn't Fred Prethro, P-R-E-T-H-O. And Mr. Prethro is in the Georgia State Prison System, easy to find. And Mr. Prethro was in Grady Hospital also, unfortunately suffering from a gunshot wound. And you can hear the medical equipment behind him. And Detective Williams came in and was recording the whole conversation and said how many people were in the car. And Mr. Prethro names the people. Adrian Bean, who's the gentleman I just said, himself, and Walter Murphy. Are you sure there weren't a fourth person in the car? No, the three of us. The state doesn't call that person. The state does call Detective Williams. So I wanted to ask and inquire on that. The state, to obstruct, if that's obstruction, ask the predecessor court to prohibit me from getting into the fact of any conversation that would have impeached another witness. It's fine. Fred Prethro's on my witness list as well as the detective, and I have the recordings. In addition to that, Walter Murphy gave a statement while in the hospital, and his statement is very interesting. It's two different police reports, signed the same date, which is September 11th of 2013, and on the first 7 lines of the police report, they're identical. Then all of a sudden, when it gets to, on the right-hand police report, it says, Mr. Murphy stated that there were 3 people, I believe, I have to go back, in the vehicle. On the other police report, it states, Mr. Murphy stated there were 4 people. There's no reason that they should be different. They're both signed the same. The state doesn't call that officer at all. I tried to ask Mr. Murphy about it. The state objects, and the predecessor judge sustained the objection. Mr. Williams was not involved in the Mr. Dotson. Miss Bennett, that was Mother's Day, May 12, 2013. She reports allegedly an armed robbery. The detective who testified here and investigated stated he never took out arrest warrants for Mr. Williams. And he wrote in his police report, Miss Bennett is not truthful. That is the case that the state is talking about. The state then, there was Brady evidence that they don't turn over, and we find out about it in court after they arrest Miss Bennett because they say she's not cooperating, and it comes out that she told the prosecution over and over again that this did not happen the way that she reported it, and she doesn't remember. As to Donovan Thomas, and Mr. Williams has nothing but empathy, sympathy, and sorrow. They were friends. It is a lie. What the prosecution has put before this jury is a lie. What happened here is the prosecution comes up with a theory because they need a motive, they think. I know you don't need a motive in reality to prove a murder case or any other case, but they wanted a motive. So they made it where Mr. Williams and a gentleman named Rich Homie Kwan, his name is Mr. Lamar, he's a performer, and Mr. Williams and Mr. Lamar were close. There are public documents, recordings, Mr. Lamar being interviewed almost every year, and then he talks about his time with this band or group called Rich Gang, and he says every year up to this past year, he God forbid died, we can't call him as a witness, how close he is to Mr. Williams. The state, though, made it in this case, or tried to make it, that Mr. Williams and Rich Homie Kwan are enemies because Rich Homie Kwan will not sign with a record label that has nothing to do with Mr. Williams. Mr. Williams doesn't sign to that record label. That record label is owned by a gentleman named Brian Williams, also goes by Birdman. Wildly successful. He started Drake's career. He started Mr. Dwayne Carter, performer known as Lil Wayne's career. He started Nicki Minaj's career. Just fabulous, powerful person, well respected in the industry. But the state wants it to be that Donovan Thomas interceded and would not let Rich Homie Kwan sign to Mr. Brian Birdman Williams, and that is the reason that Jeffrey Williams had a feud and killed Donovan Thomas. Your Honor, what the evidence would really show if we kept going to trial, and I could tell you that Mr. Adams and I never thought we'd be in front of this honorable court. We always thought it would go all the way through trial. Was the state is saying that Rich Homie Kwan and Jeffrey Williams don't speak since the fall, and they have a bad relationship the fall of 2014. We would have shown, and we served on the state, December 15, 2014, Jeffrey Williams in a private plane with Mr. Lamar or Rich Homie Kwan, and they are high-fiving and laughing with each other. That is on audio video. There's a man who the state hasn't called yet, Mr. Martinez Arnold, also known as Duke. It's on the state's witness list. He's represented by the Honorable Ashley Merchant. He's on that plane as well. He would have identified the item, and he would have testified that Mr. Williams and Mr. Lamar were very close in December 2014. Then on December 29th of 2014, Mr. Williams, Mr. Rich Homie Kwan, Mr. Arnold, others were at Brian Williams' home in Miami, Florida. There is a posting by Mr. Lamar, Rich Homie Kwan, and a picture of Mr. Arnold and Mr. Lamar, and they said, Mr. Lamar says, "This is my number one man, Duke," or something to that effect. We would have put that into evidence. In addition to that, Your Honor, on December 8th, 2 days before Mr. Thomas, God forbid, was killed, Mr. Williams is with Mr. Thomas, as well as Mr. Sledge and Brian Williams in Brian Williams' tour bus outside of a fabulous entertainer, artist, Mr. Clifford Harris, T.I.'s studio, and at that time, they were very close. But you also have the detective with the gang unit, Detective Underwood. I asked her within the last 2 weeks or 3 weeks, did you do any, and she was on the gang unit the entire time, including today, and I asked her, do you have any evidence about Mr. Williams and Mr. Thomas being close friends? And she said, yes. Of course, I knew that. I said, how about in January of 2015, close to time of Mr. Thomas's death? She said, yes, they were close friends. Mr. Michael Sprinkle, he's a deputy district attorney in the Fulton County DA's office. He has a recording with Mr. Treadwell. You've heard the name O.G. Bentley. And in that, they're going through the evidence. And Mr. Treadwell, it's important because he has a child, two actually, with Mr. Thomas's sister. He's family. And Mr. Sprinkle states this is 2018, this is after the rental car, this is after all of the interviews of Mr. Copeland, this is after the interviews of Mr. Zachary. Mr. Sprinkle's in some of those interviews with Mr. Zachary. Mr. Sprinkle on tape, on recording, states, I do not know why anybody thinks Jeffrey Williams is involved in this killing. He and Donovan Thomas were close friends. It makes no sense to anyone. And Mr. Williams was never arrested, never charged, even in this, as the court just noted, with anything to do with Donovan Thomas's, God forbid, killing. In addition to that, Donovan Thomas has a place that he used to stay with a group of people on Auburn Avenue. Jeffrey Williams performed and did a music shoot there to try to help other people who are suffering in poverty to get out and to be able to be seen and to broadcast their music. Jeffrey Williams does that for everybody because he comes, Your Honor, from the struggle of total poverty, seeing people killed. He saw his brother die right in front of him, and the law enforcement, I'm not blaming anybody, everybody's on edge, but law enforcement would not get any help for him because there are all these people around.
It's the real with the vision one more time. Wow, welcome back.
It's wrong for everyone. It's not just Mr. Williams, it's that whole community, but he's trying to get people out of poverty and out of that community. I have been with Mr. Williams where we have gone to speak with children together. And he tells them, don't be a rapper. Be like Brian. Be a lawyer. Keep in school. He tells his children, get your education. His family, his whole being, Your Honor, is trying to break the chains of poverty for others, and it has been spun in this courtroom with false statements and allegations against Mr. Williams at every turn. In addition to that, Your Honor, the state talks about the fact that Mr. Williams takes people to Miami. You would have heard evidence if we went forward. I put all these people on my witness list. Not one person on my witness list has been interviewed by law enforcement or the prosecution. They have investigated this case for 15 years. They haven't interviewed all these people.
Long time, I think.
The Sprinter van that you heard about, that was already booked days before. Going to Miami, Florida, Mr. Williams and Mr. Brian Birdman Williams, they did a video shoot for a music video. If anybody would have gone further with the expert for the state, they would have seen that Mr. Williams' cell phone does not contact any of the co-defendants that are named here in Miami, and Mr. Williams stays at a separate location than any of those persons. He would always take people who can't afford it on airplanes, on buses, on tours, to his concerts. He let everyone go because, Your Honor, they never left that area. He wanted to show people you have an opportunity. The world is big. Mr. Williams gave jobs to everybody who'd want to work. He'd give them jobs and security, and I'm not insulting them. They really weren't their jobs. but they were being mentored, but they were given titles and tried to give them respect and opportunity. But if they did not wish to work, Mr. Williams would not allow them to work with them. This has all been turned on its head by the state. The fact that the state has put in Mr. Williams' lyrics are offensive. Mr. Williams has tens of thousands of recordings. On our witness list, we are bringing in all of his people, his recording artists, his engineers, his managers, his record label, and an expert, the Honorable Dr. Eric Nielsen, to talk about how Mr. Williams creates his music. His music is then changed around and merged. Mr. Williams, some of the lyrics you just heard are not even uttered by Mr. Williams. The state has no idea when these lyrics were made. Some of them were made before the shooting of Donovan Thomas that the state is saying this applies to the Donovan Thomas killing with the Tahoe. They are so far afield of where we need to be when we are trying to, God forbid, take somebody's liberty, Your Honor. The state is talking about things like F the judge and I rep my life for real. That's not even said by Mr. Williams. But they don't care to find out. They are on a tunnel vision to try to convict a man who should not be convicted. The statement about I never killed nobody, but I got something to do with that body. If the state just bothered to talk with anybody, that is a Nicki Minaj song with Jeffrey Williams. It is written by Nicki Minaj. That is on the text messages I gave, not the text message, the Instagram or Twitter rather, that I gave to the state. That is out well before this, but the state doesn't care. This is out in 2015 or 16 or 17 or 18, I can't remember, I think 18, where Mr. Williams is asked who wrote anybody, and his response is anybody was written by Nicki Minaj, and it was. But it was really written and sung, it's a takeoff of a song by Tupac. There's a song that it parallels, which is an inspiration. But here we are with the state. Also, I never killed nobody, but I got something to do with the body. The next line comes up is, it's a truancy body. The state can't explain that, so they just conveniently leave it out. Your Honor, there were wiretaps on this case. Mr. Williams, it was going to come out, there was an application to wiretap his phone. The state never presented to a judge. That speaks volumes. The leader of the YSL criminal street gang, who's been involved from 2012 until his arrest, and even according to the state, while we sit here, they never even tried to wiretap his phone. It might have been because they don't really know what his phone number is. So all these communications you're being told about with Mr. Huey, I'm not so sure the state could have gotten anybody to say that's Mr. Williams' phone. This is how the trial has gone for us. But we sit here for almost 2 years since we did our jury selection initiation on January 4th, 2023. Mr. Williams has been sitting in a jail since May 9th, 2022. This is 2.5 years waiting for the conclusion of the state's case and a verdict from the jury, and that's why he is tendering this plea. I'm telling the court this, and the court knows when you came out the first time, it's very hard for Mr. Williams. I am not supportive of what we're doing right now. I'm not against it. But I told Mr. Williams, you okay with me saying this? Yes. I told Mr. Williams that I think we're winning the trial and we should go to verdict. But he told me I can't wait another 3 months if there is any possibility I could go home because I have children that are hurting. I have things to do, and he has some medical issues that he would like to tend to. He eats out of a bag, Your Honor. He eats processed food only. He gained 75 pounds during trial. He's lost it since. But it is hard. You know, for me, it's only 3 more months. It's enjoyable, actually. I enjoy coming. It's not that enjoyable for Mr. Williams. He told me he wakes up. Can I say this? Yes. He wakes up every day, and it's another day in HE blank blank. Your Honor, the state is talking about in this case, they put in social media. The Honorable Court was not here, but the state put in that Mr. Williams, in the indictment, Mr. Williams put out a call for murder. He put $24 million, murder for hire, on a person's head. That is a lot of money, and that is awful. If they would have read the chat, the Instagram chat, Mr. Williams, right above it, there's a picture of a very well-known, very accomplished musical artist who actually had surgically implanted in his forehead a pink diamond worth $24 million that day. That's what Mr. Williams would talk about. That's the type of evidence that is coming from the state of Georgia in this case. It is wrong. This is all wrong. And I know we're pleading guilty, and I know we're pleading nolo, and I know we're asking this Honorable Court for a certain sentence, and we'll get to it with the Court's permission. But this is the type of evidence that there is. But it is holding this man hostage. And that's not really what we're supposed to do, district attorney time, in the state of Georgia or anywhere. The state then, because I opened on that, then they never bothered to put in all of the chats. Why did it take me to read the chats? In addition to that, going back to Donovan Thomas, talk about Mr. Williams involved, the state did a geofence. A geofence tracks his devices. It doesn't have to be a phone. It could be an iPad. It could be any type of electronic device that targets and is used. You don't have to be on the phone. It's the contact. If he has an app open, it'll capture it. And the state targeted the McDonald's, where they keep saying that Mr. Williams met with people there. They targeted the barbershop where, God forbid, the killing occurred. And they targeted two locations. And it comes out, Mr. Williams' devices are not there. It's exculpatory. I don't get that information. I got that because I interviewed Lieutenant Crabtree, and the results can't be found, according to prosecution. I did a motion for that. They just can't find it. That is great evidence for Mr. Williams. It would have also shown clearly that when he does go down from his house after getting this call that I'll talk about from Demise McMullen, he's not with these other people. And the expert for the state, the FBI agent who does the telephone analysis, Mr. Williams' phone does not ping off the same tower as a Demise McMullen or a Mr. Copeland or a Mr. Garlington or whomever. The state of Georgia has misrepresented for 2 years in front of this jury. They have hidden evidence. They have violated Brady. They have falsely accused Mr. Williams. Your Honor, saying that Mr. Williams gets that call 7 minutes after, the state said 6, it was 7 minutes after the killing of Donovan Thomas from Demise McMullen. Mr. Williams was already out of his home. Mr. Demise McMullen is calling Mr. Williams. He's not even there. He's going down to meet with Mr. Kelvin Treadwell, also known as O.G. Bentley. O.G. Bentley was supposed to go to Miami, Florida. They were talking about this deal. And Mr. Williams, that day, he was given another contract. Mr. Williams, by this time, he went from zero money. He is a multimillionaire at the time. He doesn't need the Cleveland Avenue drug deals for $15. He doesn't need the shootings. He wasn't even living in Atlanta since 2018, 19, 20, 21. He came back the very end of 21, 6 months, and he got arrested in May of 2022. In his house, Your Honor, we have everyone on the witness list. There are 12 people living at that house. Mr. Williams opens up any of a car that he has. He'll rent cars for people. Any home he has, he will allow people to live in hotels because people that he knows, unfortunately, are homeless. And he gives them all places to stay, cars to drive around. He is not involved in criminal activity. Mr. Williams just got back in our country. His passport shows it. Right before he was arrested on May 9th of 2022, there were other people in the house with the drugs and the guns. There are people whose the guns are in their names. They were going to come in court and claim the guns. Everybody else was doing as well, but Mr. Williams has entered a guilty plea. I'm not going back on that, but I just want you to know that this case is just wrong to do to somebody with no bond and to hold him hostage. He wants to, you may not do it, he's aware of that. He's aware of that. But the state offered him 15 years on probation. But they keep piling on these conditions. He just said, he made up his mind. He said, I'm just going to go with it. I got to get home. Judge may not let me home, but I'm not doing these conditions and admit that I'm the leader and I'm involved in the killing and my music just promoted everybody to do it. He's not going to do that. So he did not do that, and that's how we wound up here. The state, the night of the killing, people came to Mr. Williams' home. The state tells the court, he said, lay low. What they don't tell you is right after that, he gave money to Mr. Sledge, who said, they're going to kill me. They think I did it. And Mr. Williams said, if you had anything to do with it, I don't want to be with you. And Mr. Sledge said, I just need a hotel room with my children and my bride or my significant other to get to. And Mr. Williams said, be safe, lay low. That's the lay low. In addition to that, Mr. Williams told Mr. Copeland, Mr. Copeland's with the police. Hours after the killing of Mr. Donovan Thomas, Mr. Copeland goes to the police department. Mr. Williams is the person who told him to go. Mr. Copeland said, what do I do? They're shooting at my house, at my family's house, at my significant other's mother's house. And Mr. Williams said, if you had anything to do with the murder, get out of here. Mr. Copeland denied it. And Mr. Williams said, then go tell the police. Mr. Copeland said, you want me to go to the police? And Mr. Williams said, if you had nothing to do with it, they think you did it, go to the police. In addition to that, Mr. Copeland said, well, I'm going to retaliate. Mr. Williams told him, don't do that. Let 12 handle. That's on recordings. That is on recordings on January 11th of 2015 with Detective Thorpe. Your Honor, as far as Dwayne Carter, a performer known as Lil Wayne, Mr. Williams had no conflict with him. They are friends. We were presenting evidence that right before this shooting of the tour bus is April 26th of 2015. Mr. Williams is performing in New Orleans area. Then that's the area where it's Holly Grove, where Mr. Carter, or Lil Wayne, the performer known as Lil Wayne, comes from. And in order to drum up popularity and interest, people get on the internet and they start what's called rap battles, arguments, feuds. That's what happened here, and you would have heard testimony from Mr. Williams' management that they said, start a rap battle. It'll be better for your career. Mr. Dwayne Carter is aware of that. Mr. Dwayne Carter's interviewed. The state's aware of this. He has interviews after this. Are you mad? What's the real deal with Jeffrey Williams? He states, no. He's great with me. He brought popularity to me. He loves me. He idolizes me, and I love working with him. They did an album together. In 2014, they're in the studio together, making music together. It is all made up that Mr. Williams is involved. Mr. Williams gives a statement. The state refuses to put it in and then stopped me, the previous judge, from cross-examining the detective. His name is Racy. He met with Mr. Williams in the DeKalb County Jail on the 15th day of July 2015. Mr. Williams is arrested that day. And there's a long interview. And Mr. Williams waives his right to counsel. He tells them, I'm his lawyer. They say, you don't want to speak to us? You don't have to. He said, well, I'll speak with you. And they asked Mr. Williams these questions. What about Lil Wayne's shooting? He said, it was outrageous. I love him. That's my idol. I love Lil Wayne. How about this battle? He says it's promotion. They asked him about his rap lyrics. It's the only person that the state ever did anything about rap lyrics with. And they asked Mr. Williams, what about the rap lyrics? And he tells them, it's hyperbole. He didn't use that word. He used the word, it's made up. It's rhyming. It's made up. Not like the state is saying that I rap lyrics for real. That's not even Mr. Williams' utterance. Your Honor, the point I'm trying to make to you is what the state of Georgia has presented to this jury in this courtroom the past year has been full of untruths, and they know it. The state says that Mr. Williams had a conflict because he named an album with Dwayne Carter, and Dwayne Carter didn't like that. Dwayne Carter's interviewed. He said that was one of the nicest things anyone could have done to me. It shows how much he really appreciates me. It shows respect and honor, and I appreciate what he did. The state knows this. With regards to Jimmy Winfrey, what the state did is they put in a recording. It's not Mr. Williams. It's a jail recording, Mr. Winfrey and an unknown person. And an unknown person says, when you get out, you're going to get a Porsche and $250,000. Mr. Williams not privy to that. The state looked at all of Mr. Williams' bank records, everything. They undressed him financially. There's zero evidence Mr. Williams did anything for Mr. Winfrey. The state tells you that Mr. Winfrey asked for money for a lawyer. The conversation was, and it's recorded, it was with Mr. Williams' manager. And Jimmy Winfrey said, I need to show that I was gainfully employed for the court. Can you get me something from YSL? And the manager said, yeah, if we have it, and if it's true, yes, you can have it. That is it. There's no evidence that Mr. Williams paid for anybody's lawyer, Mr. Winfrey or otherwise. In addition to that, Your Honor, the social media postings with Mr. Rashawn Bennett, also known as YFN Lucy. So Mr. Williams, the state tells Mr. Bennett on social media, I would have killed you if I didn't like the way you take care of your mother and children. That is the post. What they don't tell you is Mr. Bennett, who is also, to his credit, trying to drum up his career. Mr. Bennett is picking on Mr. Williams, who's a much higher profile artist than Mr. Bennett at that time. And Mr. Bennett is saying that he slept with Mr. Williams' fiancée, while Mr. Williams and she are a significant couple, that Mr. Williams' music is awful. Nobody should listen to his music ever. Mr. Williams responds by saying, we can do an album together if you want. Stop this. The man continues of how he's sleeping with Mr. Williams' significant other, and then Mr. Williams responds by saying, I would have killed you except for what you do. That is the context that they don't tell you about. And Mr. Williams did nothing to Mr. Bennett. In fact, the evidence would have shown, if we had time or we would have gone forward, that Mr. Bennett and Mr. Williams are on the red carpet receiving awards in California, sitting right next to each other and taking photographs. This is not the Jeffrey Williams. Jeffrey Williams is a known person who is all over the place. If he did something, somebody wanted him, they can find him. He is not hanging out on Cleveland Avenue. What the state is saying are not true. The situation with Mr. Bennett, so he's in the Fulton County Jail, and he's housed, and there are crazy, sick, violent people, and they're on the phone, and Mr. Myrick, M-Y-R-I-C.
Be healthy, stay healthy with Buckeye Medicaid.
Care Manager Page is there for me through Buckeye. They've helped me get my health.
Kenneth Copeland, Demikian Garlington, Justin Cobb, Demise McMullen, Mr. Sledge, Mr. Murphy, all these people, this is a lie. This is a 100% lie, and that's why we tendered a NOLO plea to being a leader of a criminal street gang. Mr. Williams is not a leader. In fact, if it would go forward, on Mr. Huey's phone, there are conversations with Mr. Copeland. And they both say how Jeffrey Williams is a zero and F him. And they don't talk to him, and Jeffrey Williams never does anything for them. Mr. Huey, Mr. Williams met later. He met him closer in the time of 2020. Mr. Huey's father went through a horrible episode that Mr. Williams knew, and that's how Mr. Williams knew his son, who's Mr. Huey. And Mr. Huey's on hard times, and Mr. Huey's making mistakes. And Mr. Huey, supposedly, Mr. Williams believes, armed robbed a man named Chandler Durham, D-U-R-H-A-M. Mr. Durham is Mr. Williams. He's a fabulous record engineer. And Mr. Williams states, give him back, tell him to give back the property or he's going to die. The state puts that as an overt act. No one dies. The property doesn't get returned. Mr. Huey ignores Mr. Williams. The state told you today that Jeffrey Williams sent Mr. Huey a posting that Mr. YFN Lucci is going to be performing on January 19, 2020. That's not true. Mr. Huey sent that to whoever phone that was, and all it says is Slat and Slatty. Well, I went out to the places that Mr. Bennett was supposed to perform. There's no shooting. There was no fight. There was nothing to report. There's nothing here. In addition, the state says same thing on September 2nd, 2022 on Mr. Huey's phone. I'm not conceding that was Jeffrey Williams even having a conversation with him, but even if it was, it doesn't show anything. It says Slatty, lay low. Lay low means don't do anything. Get out of the way. That is what it is. That is Mr. Williams' role. Mr. Williams, there is evidence in the record, and there would have been more. He takes people on tour with him. He takes people in the mall with him. But when they do crime or do things to people, for instance, there was a prostitute, and several people gave that prostitute money, $500. And the prostitute, at the end of the $500, getting $500 from several people, had sex with a person, and then she was armed robbed. So all the money came back. Mr. Williams wasn't involved in that, but he heard about it. He made those people find the prostitute and repaid her every dime. People stole from stores that Mr. Williams found about. He went to the stores and he repaid all that. He didn't steal anything. He doesn't need to steal anything. Your Honor, Mr. Williams stands with Elton John. Elton John called Mr. Williams the next coming of John Lennon. Mr. Williams is unbelievable talent. He's not just a rap artist. In fact, when he's interviewed in 2017, he gives a statement and he says, I had to learn rap. He grew up in a house learning other forms of music. He likes all music. But rap hit in his community, and his community raised him. They supported him. They came out to him. They made him get into establishments. And once the establishment saw all the people come out, he got more establishments. And then he went out of that little area in Atlanta to other parts of Georgia and then to all the neighboring states and throughout our country. And he has performed on every continent but one. He has performed in front of being the headliner, 300,000 people at one time. He has a real life and career. He is not the leader, and he is not worried about buying jewelry that is stolen. Mr. Williams is actually innocent. I'm not trying to corrupt our plea. That's his plea, and he's entitled to it, and he wants it, and he embraces it. But to me, this is a wrongful prosecution. This is outrageous.
All right, so you're pleading guilty, or your client is pleading guilty to counts 57 through 62.
It's all true.
Do you
yes,
concede
there's a factual
basis
I
for those counts?
Yes, I can see that.
So what he's doing, pleading guilty to two of them, right, y'all? And the rest of the motherfuckers,
All right, I didn't mean to
basically no
interrupt you.
contest
No,
is for nine.
Your Honor, I'll answer any of your questions, but the point I'm trying to make is 45 years to serve 25 years in prison when just this morning it was a probationary offer. It was a probationary offer. The state knows But they want to control. They have this theory of music, and they want to stop Mr. Williams from making music, from entertaining, just stop his life. That's just not right. And it's wrong of the district attorney in Fulton County to do that. If they offer probation, then he's not a 45 to serve 25 years in custody type of person, and he's certainly not the person that the state has stated in front of the court. What we're asking, Your Honor, on count 1, which is the RICO count, to accept the nolo contendere plea. Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22.5 years. On count 56, Your Honor, that's the leadership of a gang, nolo plea, 20 years to serve 5 years commuted to time served, consecutive to all other counts. On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years commuted to time served, concurrent with count 1. With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count 1. On count 59, which is violation of Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count 1. On count 59, Your Honor, which is violation of Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count 1. Count 61, 5 years of probation. It's a firearm count, consecutive to the other counts, consecutive to before count 56. And then count 62, 10 years to serve commuted to time served. That should be a total sentence, Your Honor, that we are respectfully requesting the court to consider. I believe it's 45 years to serve 5 years in prison, commuted to time served, 40 years on probation, credit for the time already served and commuted time served. As I said, after 3 years of probation, the probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated. Mr. Williams asked the court for house arrest for 3 years as part of the sentence, but house arrest specifically defined that Mr. Williams will be in his home or at any lawful employment, touring, studio, performance, business meetings, and the like, wear an ankle monitor for the first year and pay the costs of same, and the company must be approved by probation department, and the ankle monitor to be affixed within 10 days of hopeful release from custody. Mr. Williams cannot possess a firearm, but he can be around licensed security who are armed or other persons who are lawfully carrying a firearm with a license. And that would be knowingly for Mr. Williams. Mr. Williams can transfer probation outside the state of Georgia. He has residences in the state of California. He has studios in the state of California. Mr. Williams be allowed to travel throughout our country and the world for lawful work-related industries. Mr. Williams wants to perform. He's going to do this anyway, Your Honor, but we made it part of the sentence. At least one concert each year at a venue, if they'll have him holding 10,000 people, if that is workable for the venue and Mr. Williams' management, and he is going to donate all of the profits that he makes to a 501c3 charity. Mr. Williams wants to pledge $100,000 for the next 3 years.
Put that money in their face, hit them with all the money, put like $1.5 million and make sure you come up out of this bitch.
To buy back firearms that are not supposed to be on our streets. Mr. Williams does not wish to go near the Cleveland Avenue area. Not to insult that area at all, but it is just not a good idea under this circumstance. And he can drive on the highway, but otherwise not come within 1 mile of the area that we call Cleveland Avenue, and we can give the exact dimensions of that area. Mr. Williams must perform 100 hours of community service per year for the next 3 years as designated by probation department. Mr. Williams can associate, and this was agreed to previously, with people who are convicted felon or alleged gang members.
Injured in a car accident? Want to see if you qualify for a huge check like this? Don't call insurance. Don't.
See Ms. Love shaking her head, and I think it's fair to establish that until the entirety of the negotiations were agreed to, it was all up in the air.
Sure.
That may have been something y'all had already hammered out, but it wasn't. It's not anything they're bound to.
Absolutely.
Fair. Okay.
I agree with that. Mr. Williams can have no contact with any of the supposed victims, and there was an Exhibit A attached to the state's proposed plea agreement, negotiated plea agreement that was sent to you, so we adopt that Exhibit A, but we can give it to the court if you need those names. And Mr. Williams have no contact with any of the co-defendants in this indictment, with the exception of Mr. Quantavious Greer, that is his biological brother, as well as Mr. Sergio Kitchens. He's a phenomenal artist. He goes performer known as Gunna, G-U-N-N-A. Mr. Williams and Mr. Kitchens are contractually obligated, and they frequently perform music together. Your Honor, any other conditions that this honorable court deems appropriate? I want to thank the court for all your time, always. I want to thank Ms. Persifield for everything she has done. I want to thank Mr. Williams for allowing me to stand with him. And I really never thought we would be here, but this is his decision. I want to thank the Honorable Keith Adams, who may want to speak, Your Honor, but I can never imagine a better lawyer than Keith Adams.
Mr. Adams, do you want to add anything to the record?
Your Honor, I don't know that there's really much to add. Mr. Steele has represented to the court, I think fully and thoroughly, the breadth of our knowledge of the case, Mr. Williams' background. I think the court has not just heard it from Mr. Steele, but has had the opportunity to sit here and hear some of the evidence and kind of get a feel. You've had a chance also to observe Mr. Williams and then get a feel for him, his background, and so forth. You know, the only thing I can say about Mr. Williams that hasn't been said is that he comes from an area. You might have heard throughout the course of the trial that there was an album, a concert tour. We came from nothing, and that is true. Mr. Williams came from, you know, I hate to use the word abject poverty, but that really is the case. Came from an area where there was a significant amount of crime, where, as you've heard, he's had tragedy in his life and has observed tragedy in his life, and he has gone through a good bit. He has been involved in a lot, but he has raised himself up. He has done the best he could and has done phenomenally well, and is, I think, an inspiration to a lot of people from that community who look to him and see the success that he has gained and have been fully supportive of him. But he finds himself here. He's in front of you. He is tendering this plea because he accepts responsibility. You have heard everything Mr. Steele has had to say. I can only ask that you follow what we have put before you. You also have, I believe, the paperwork that was given to you by the state, which kind of gives you some idea of what they were looking for as well in terms of conditions on Mr. Williams if we were to ever reach some sort of agreement. And we ask that if you feel that there is anything within the state's proposal that might be appropriate in terms of the sentence for Mr. Williams, that the court please feel free to do that. There is nothing that he puts himself before the court. And I think 2.5 years sitting, going through this process, challenging the process, but now standing before you and asking that you consider everything and sentence him appropriately in the way that we've requested, I'd simply ask you, I'd join Mr. Steele and Mr. Williams in asking you to do the same. And I thank you as well, as Mr. Steele did, for your patience with us and for bringing some order to the proceedings that candidly was needed. So that's all I have to say. I thank you again, and I ask you to consider everything that's been put before you.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full responsibility for, my crimes or my charges. I want to say sorry to my family, my mom. My mom got 11 kids. I can't say all their names, My managers, my kids that's not here. Really everybody that got something to do with this situation, I want to say sorry for just having so much time invested into this, and I am a smart guy, I am a good guy, and I really got a good heart, I find myself in a lot of stuff because I was just nice or cool, and I understand that you can't be that way when you reach a certain height because it could end bad, and it don't really have to have nothing to do with you, but it could end bad and it could, fall on you. And I know the choice is yours, it's up to you, and I hope that you allow me to go home today and just trust in me to just do the right thing and never see you again unless it's at a bar in the future or something. Just out of this type of situation, I promise you I won't ever be in this type of situation again. I'm going away. I've learned from my mistakes. I come from nothing and I've made something and I didn't take full advantage of it. I'm sorry. Through these last 2.5 years of my life, you are really, truly, honestly, the best thing that has happened to me because you made everything fair for me and everybody involved on both sides, I'm sorry to the sheriff, everybody for just having to put extra time in. I know y'all got paid more money, but I'm sorry for y'all having to put this extra time in to be away from y'all family, and I just hope that you find it in your heart to allow me to go home and
take a better chance,
be with my family and just do better as a person. I know what I bring to the table. I know what I am. I know the heights I've reached. I know the impact I got on people, period, in the community, all people. I learned that late, these past 2 or 3 years of my life, I kind of learned that late, and maybe it was because I was, probably on drugs or anything, I don't know, but I have came to my senses and I understand what I mean to this world, but I am a good guy, I don't mind doing stuff like free shows, and I always did that, I did free shows and gave it to single parents, millions of dollars, I made $1.8 million on a free show, and I gave it all to single parent charity, and I did 2 or 3 shows that made $700,000 a piece, and I gave it to the breast cancer organization. I do things. I put millions of dollars back into my community for real. I really did. I did more than anybody ever did from my side, But I understand, rap lyrics. I understand how it could be twisted. I understand what it could do to the minds of people. I understand all that, and I promise you I'm 100% changing that. It's just I'm older, I'm grown now, and it's just I'm smarter. It's more things to rap about. I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever. Well, I appreciate it, and I appreciate that you do realize how much of an impact you have on people. It's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around
that, you know that gangs are damaging to our community, and it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do, look at him, he's a millionaire, I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are, you know, by far the most likely outcomes. And, you know, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do, and that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, you know, I mean, he might have rapped too in this day and age. I don't know, but I know you're talented, and even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, you know, I know that happens for protection sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go on.
Post Malone is teaming up with Raising Cane's to empower the next generation of artists for a limited time to exclusive.
More of the solution and less of the problem. I mean, all right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution and less of the problem. All right? All right. So it is not lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss the, you know, machine gun count.
Let's go with it, girl.
Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And
she about to let that nigga out.
She
about to let him out right now. Go let the boy run,
one
man.
Of the two
let him out.
Counts, I would not be permitting Manolo to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged, I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count 1, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count 2, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count 1, but I am going to backload. Oh, I'm sorry, that is not commuted. That is 5 years to serve, and it's going to be run consecutively to count 1, backloaded, by which I mean after you serve your 15 years of probation, if you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is pursuant to OCGA 17-10-1, subsection 2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do they mean?
Can I have a second, Your Honor?
Sure.
Like the judge. Thank you, Your Honor.
All right. You had enough time to talk with your attorneys?
Yes.
Okay. All right, special conditions of your probation. After 48 hours from your release, you are to stay away from the metro Atlanta area, and that's defined by the U.S. Census Bureau. It may change, but you can look that up anytime to figure out what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined the same way that you all were contemplating it when you were negotiating. You can get here up to 24 hours prior to any such event, and you need to leave within 48 hours after any such event. In addition, during each year of your probation, I'm going to require that you come to the metro Atlanta area and make a live anti-gang and anti-gun violence presentation 4 times a year each year of your probation at a grade school, a middle school, a boys or girls club, anything like that, that type of group. And if you want to, that presentation can include a benefit concert, and these presentations may count towards your required community service hours, which I'm going to impose, that during each year of your probation you perform 100 hours of community service. You are, and this is required by the fact that there's a gang conviction. You shall not knowingly have contact of any kind or character with any other member or associate of any criminal street gang. Exception to that, if your brother is a member of any street gang, I hope you talk him into getting out of it. Quantavious Greer, and then also Sergio Kitchens, as long as you are contractually obligated to him. That is going to include anybody who is named in this indictment, except as absolutely necessary to conduct the lawful business of your musical career, and to any extent that the state is not agreeing to the exception for Mr. Kitchens. In the event that that part is not enforceable because it is only a portion of a special condition, going to provide that that be severable from the rest of this, and I'll put some case cites in the Senate sheet for that. You are in no way to promote any criminal street gang or any criminal street gang activity, including on any social media platform. You are not to utilize any hand signs, terminology, or language that promotes any criminal street gang. You are not to participate in any criminal street gang activity. You are not to knowingly engage in any contact with any of the victims that are listed in this indictment or with any of their family members. And you may not have in your possession or with arm's reach any kind of a firearm, because you're going to be a convicted felon. And that is, except I know that you have security and you need security. You can be within arm's reach of a firearm that is in the possession of either licensed law enforcement or licensed security personnel that are in your security detail or anybody that you're performing with. You are to submit to random drug screens and not use any drugs unless they are prescribed for you by a licensed physician. You are to execute a Fourth Amendment waiver that will permit the search of your person, residence, vehicles, and electronics for any firearms, any criminal street gang paraphernalia, or any illicit drugs. And as I mentioned, with regard to one of the first of your co-defendants from this trial, at least since I've been involved, to plead guilty, our Uniform Superior Court rules instruct and provide that it is absolutely proper for a judge to grant leniency in sentencing when, quote, the interest of the public in the effective administration of criminal justice are served, unquote. And I think that this plea is in the interest of the public and in the interest of effective administration of justice. Have been trying to ensure that, to the extent I can, this trial also abides by that. It's been challenging at certain times. I find your plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I accept it as such. I also need to inform you that your attorneys were going to represent you through either the last day of this term of court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things and to do and continue to do things that benefit your community and especially help young people to stay out of criminal trouble. And unless there is anything from council other than that.
I have one matter, Your Honor.
Your vote is your power to protect your rights, to strengthen your community, to change your future. Use your power. Vote by November 5th. Learn more at vote.org/Ohio.
Because I know you do travel all over in order to pursue your career, that it's permissible for your probation to be, nobody's mentioned it, but keep your passport and travel out of state and internationally to the extent that you need to do that for business purposes as well. All right, Mr. Vadi.
Yes, just very briefly, and thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by what has been discussed by both parties here today, to make a brief statement as she believes that they fall within the exception or within the bounds of Marcy's law. If the court would allow, I understand the court made a ruling earlier as it relates to that, but she wanted to
All right, thank you, and I appreciate, well, I cannot even begin to understand what they must, anybody must be going through when they lose a family member to violence or criminal violence. Mr. Williams himself has expressed his own sorrow to the family. I, again, am going to stand by my belief that the appropriate time to hear a victim impact statement from them is at the close of the trial that contains the murder count with regard to their family member. All right, thank you. Okay, court is adjourned. Good luck to you. And I'm going to have there better be no violations, but if there are any, you're coming back to see me.
Yeah.
All right.
Thank you, Your Honor.
That takes care of that.
Since the offer for Mr. Kendrick and Mr. Silva are firing, off the record.
Let's take a recess, and I'll be back.
I wonder what they're going to be trying to discuss. It's always something. Oh, sound pretty sweet to me.
Absolutely proper for a judge to grant leniency in sentencing when, quote, the interest of the public and the effective administration of criminal justice are served, unquote. And I think that this plea is in the interest of the public and in the interest of effective administration of justice. Have been trying to ensure that, to the extent I can, this trial also abides by that. It's been challenging at certain times. I find your plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I accept it as such. I also need to inform you that your attorneys were going to represent you through either the last day of this term of court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things and to do and continue to do things that benefit your community and especially help young people to stay out of criminal trouble. And unless there is anything from counsel other than that.
I have one matter, Your Honor.
Okay, and does the state as well?
Yes.
Your Honor, with regards to Mr. Williams being permitted to come to the Metro Atlanta area or Cleveland Avenue area for funeral or the other items,
right.
Can you also consider, God forbid, there's a serious medical condition of a person that is...
In his immediate family,
yeah.
Certainly, we can add that. And I also meant to mention, because I know you do travel all over in order to pursue your career, that it's permissible for your probation to be transferred to out of state, and that has to be done through probation, but that is fine with the court. And you may also keep your, nobody's mentioned it, but keep your passport and travel out of state and internationally to the extent that you need to do that for business purposes as well. All right, Mr. Vadi.
Yes, very briefly. Thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by what has been discussed by both parties here today, to make a brief statement as she believes that they fall within the exception or within the bounds of Marxist law. If the court would allow, I understand the court made a ruling earlier as it relates to that, but she wanted to give the record as well.
I'm between Freebird and Skull Shaver. Which is the better deal? I'd go with Freebird, and here's why.
You need to leave within 48 hours after any such event. In addition, during each year of your probation, I'm going to require that you come to the Metro Atlanta area and make a
Lil Durk recently looks like he's made a complete life change. Just recently he was on he did a concert. He put everybody that died in Chicago, he put a picture of them up there to, to honor them. Even people that he was enemies with, just to honor them. What do you feel about him converting? This is a guy that didn't do it in jail.
You want me to be honest?
I do.
I think so. Man, the troll in me, man, wanted me to say, man, but the man in me, in my spiritual eyesight, says that he's sincere.
I don't know what the fuck Charles is saying. It's only any. Right.
Club them levels. I didn't know y'all was just getting started.
Appreciate it.
And you saw how in awe I was when I found out what? I immediately said, y'all what Wally and Gillo and them was, yeah.
Come on.
That was my first response to y'all, homie. So,
I love how you always calls them Wally and Gillo.
so. But I was just locked up for the weekend. I wasn't arrested. See, that was people. So I had my civil rights attorney send out a cease and desist letter to a lot of platforms because they was posting as if I got arrested and these was new charges. So those wasn't new charges, homie. I had to sit in the weekend for a jail with no bond for violating my bond conditions. Mm-hmm. So the judge went off my bond and made my bond insufficient for testing positive for marijuana.
So,
hey, did you know you might get a big cash payout if you were in a car accident?
A popular rap artist is behind bars after a shocking arrest, as authorities accuse him of being connected to an alleged murder-for-hire plot. Chicago rapper Dirk Banks, better known by his stage name Lil Durk, was arrested yesterday after allegedly attempting to flee the country, and at this time he's being held in a Broward County jail in Florida, awaiting transfer to the U.S. Marshals. According to the FBI affidavit, the Grammy Award-winning rapper is charged with conspiracy to commit murder for hire. His arrest comes on the same day as federal prosecutors announced in California the charges of 5 other men.
And deal 5 years.
Men for the attempted murder of Georgia rapper Quando Rondo, whose real name is Tyquan Bowman. Prosecutors say those 5 men all have ties to Chicago gangs and all targeted the Georgia rapper in retaliation for the murder of Chicago rapper King Von. According to prosecutors, all 5 men, who include Kevon London Grant, a.k.a. Vonnie, Asa Houston, a.k.a. Boogie, David Brian Lindsay, a.k.a. Brown Eyes, Keith Jones, a.k.a. Flocka, and DeAndre Dontrell Wilson, a.k.a. Didi. They all face charges including conspiracy to commit murder for hire, committing murder for hire involving death, and use of a machine gun in a violent crime resulting in death. And the most serious charge carries up to the death penalty if convicted. According to prosecutors, all 5 men have ties to Lil Durk's hip-hop group Only the Family, also known as OTF. OTF was founded by Lil Durk more than a decade ago. And according to the FBI, OTF members engage in violence, including murder and assault, at the direction of Lil Durk and to maintain their status in OTF. King Von, whose real name was Davon Bennett, was also a part of OTF and frequently collaborated with and was a longtime friend of Lil Durk. King Von was shot and killed in November of 2020 outside a nightclub in Atlanta. He was killed in the early morning hours of November 6th during an argument between 2 groups that escalated into gunfire. And he was fatally shot by Quando's associate Lil Tim after the argument. The indictment doesn't name Davon Bennett, a.k.a. King Von. Instead, the charging documents state a high-ranking OTF member, described by the initials DB, got into a physical altercation with someone referred to as TB, and the circumstances surrounding that incident mirror King Von's murder. The indictment says after DB's death, co-conspirator 1 made clear in coded language that they would pay a bounty or monetary reward to anyone who took part in killing TB for his role in DB's murder. That
and the whole motherfucking question is, where the fuck did they come up with this? I don't. Gotta be like, they can change this shit or the here from Chicago.
Co-conspirator is allegedly Lil Durk, who authorities say made it known he would pay a bounty to anyone who killed Quando Rondo. According to the court documents, the men used an OTF-associated credit card to buy plane tickets to L.A. in August of 2022 to search for TB, who is allegedly Quando Rondo, and using funds provided by Lil Durk. Durk allegedly texted an associate arranging the flight, "Don't book no flights under no names involved with me." And prosecutors claim when there, Kevon Grant booked a hotel room for the men to stay at and provided the others with firearms. Grant allegedly procured cars, ski masks, and firearms that were used to find, track, and kill TB. According to the FBI, there is video evidence that Durk was staying at the house in the San Fernando Valley that day. A lot of the stories that we cover here at Law and Crime are very tough to tell, but part of the reason we're able to keep bringing you these types of stories is because of our great sponsors. So I want to take a moment to thank Upside for sponsoring Easy to Use. Come out and see if your favorite
Hippo Doc. From Mini Chef in the kitchen.
spot is on the app. To find out how much you could earn, click the link in the description to download Upside or scan the first gallon of gas. According to the indictment, Kevon Grant allegedly rented 2 cars, one of which had a fake license plate for the men to use and follow Rondo and his 24-year-old cousin. But when Rondo and his cousin stopped for gas, according to prosecutors, Asa Houston allegedly drove to a nearby alley before Keith Jones, David Brian Lindsay, and a third unidentified man known in the indictment as co-conspirator 2 carried out the shooting, which was captured on surveillance video. Rondo wasn't injured. However, his cousin passed away after being fatally wounded. According to court documents, the 5 men and co-conspirators used facilities of interstate and foreign commerce, such as planes, cars, cell phones, and the internet with intent that the murder of TB be committed. After the shooting, according to the indictment, the men went to a nearby burger spot to discuss payment. Then on the same day, the credit card was used to purchase tickets for Keith Jones, David Brian Lindsay, Asa Houston, DeAndre Wilson, and co-conspirator 2 to travel back to Chicago. Lil Durk wasn't named in the charging documents against Grant, Wilson, Jones, Lindsay, and Houston. But according to the indictment, the defendants were offered money and lucrative music opportunities with OTF for the murder of Quando Rondo. Prior to Lil Durk's arrest, the Chicago rapper was being sued by the mother of Chicago drill rapper FBG Duck. FBG Duck was murdered in 2020, and his death led to several convictions in a federal conspiracy trial last January. But his mother sued Lil Durk, OTF, and King Von's estate, alleging they were all involved in the shooting as well. According to the suit, OTF operates as a criminal enterprise. After Grant, Jones, Lindsay, Wilson, and Houston were arrested Thursday, the FBI says Durk booked 2 flights from South Florida airports, one to Dubai and one to Switzerland. He then reportedly booked a flight to Italy, but was arrested in Miami before he could board that flight. Lil Durk and the other defendants are being held pending their transfer back to L.A. I want to bring on now Detective Eric Barnes to break down this case even further. Eric, thank you so much for joining me today. You know, Lil Durk is a really popular rapper, but what's your reaction to his arrest and his alleged connection to this murder-for-hire plot of Georgia rapper Quando Rondo?
Well, you know, it's a very interesting case. I've been following it for some time now, but it's very representative of things that are going on within the hip-hop community these days, of the, you know, one foot in the studio, one foot in the streets.
And talk to me a little bit about retaliation within gang culture, maybe even hip-hop culture as well, too, that we can even trace back these events in particular, kind of in a way starting from King Von's death in Georgia in 2020, and 2 years later, Quando Rondo's attempted murder where his cousin was actually killed during this ambush. What is your kind of reaction to just this whole web and trail that has been going on essentially since 2020, even probably prior to that, too?
Well, you know, one of the things that's been popular with hip-hop artists is to maintain the same group of friends that they had since they were kids. Maintaining that loyalty, not changing up and becoming a new person because you have fame. And so in keeping these alliances, you know, sometimes there's beef that follows from the streets into rap. And, you know, like I said, these guys live, you know, day to day, and their alliances also live that same lifestyle.
And, you know, reading through this indictment, there appears to be this really heavy level of planning to allegedly carry out this murder. Plane tickets were bought, cars were rented, ski masks and firearms were bought. Talk to me a little bit about the sophistication you may have noticed within the planning and these allegations.
Well, one of the things that you have to, the hurdles, so to say, that you have to get over in this case is just the geographic difficulties going from Chicago to California to commit this offense. And so there's only a couple ways you can get there. Either you can drive or you can fly. Obviously the advantage of flying gives you more of a time advantage. You can get there faster, but you also leave an electronic footprint. And that's what it seems like law enforcement was able to pick up on, was the electronic footprints that were left from purchasing the tickets. Now when you fly, you also have to have transportation on the ground. So you have rental cars. And if you're there for an extended period of time, that also leads to maybe a hotel stay.
As we talk about this level of planning, it also appears there was also this element of not so great planning if you didn't want to be caught. And some of the 5 defendants actually used their real names, their birth dates, and photo IDs to book this travel. And then one of the co-conspirators actually texted another co-conspirator saying, don't book no flights under no names involved with me. What's your reaction to kind of just doing this allegedly and using your real name, your real ID, but also kind of wanting to keep this on the down low as well, too, of not wanting to get caught?
Well, I think that when I read over that, I was kind of surprised by that, with how unhidden that was. But I think also it plays to the element of what their motivation was. And it seemed that there was some discussion of payment. And so sometimes individuals are so intrigued by being able to get their hands on whatever this payment is that they overlook small details, and leaving your name on a receipt or on a reservation is one of those things that they miss.
When we see kind of these types of cases, a lot of times I think sometimes the defendants are allegedly always kind of wanting one specific target. But then there are some cases where someone else is hurt or killed, kind of in this focus of retaliation. What are your thoughts, given that Quando Rondo's cousin was actually killed when the murder was allegedly plotted for him?
I think it's always unfortunate that innocent people get caught in the line of fire. It's something that we deal with often within street violence. But I also think within the streets, there's also a mentality when there's a retaliation and gang culture that if you get caught riding with someone that I have beef with, then it just kind of, it's the rules of the streets. Like, you put yourself in that situation, and now you have to, unfortunately, reap the circumstances of it.
And there's also been rumors circulating online that there might have been an informant or even a snitch within OTF that may have revealed more to the feds. Do you think that's at all possible in this case, that they needed an informant on the inside to kind of give a scoop into kind of how everything was planned out and kind of how everything kind of came to fruition?
Well, I know that there was very detailed information, and it definitely indicates that the investigators did a great job digging up surveillance footage and being able to uncover some of the intimate details. I don't know if there was an informant necessarily, but it seems that they do have some very personal details in their indictment.
And given if there was possibly an informant, kind of how did they all play a role into this case? Because, again, within the culture, a lot of times there is a no snitching policy. But what are your thoughts on whether or not there might have been an informant and kind of how that may have all came into this as well, too?
Well, the no snitching thing is very huge in the street and within the hip-hop culture. But one thing that within the law enforcement community, when someone is looking at a significant sentence, which I think murder for hire either carries in some sort of situations, death penalty, and also life in prison. It's every man for himself at that moment. And so the old cliche of the first one to talk is the best deal, normally that way is very...
Were you recently injured in a car accident? Look at this check for $160.
Very heavily in these cases.
Some of the defendants, in addition to being offered money, were also promised lucrative music opportunities if they carried out this murder.
Firearm by a convicted felon under 1611-133, which is also 15 years of service consecutive. So Mr. Stillwell's looking at maximum of 2 life sentences plus 85 years plus 8 since X. That is for the possession.
Right, marijuana.
Marijuana, which carries sentence of 1 to 10 years. As to count 59, I believe that's the possession of codeine with the intent to distribute, which is 1 to. Imprisonment. He's charged with count 57, which was participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He was also charged with count 58, which is violation of the Georgia Controlled Substance Act. That is for the possession.
Right, marijuana.
Marijuana, which carries a sentence of 1 to 10 years. As to count 59, I believe that's the possession of codeine with the intent to distribute, which is 5 to 30 years, and count 59, which is the possession of cocaine, which is
60 is possession of cocaine.
So 59 was the codeine, 60 is the possession of cocaine, which was 1 to 5 years. possession of a firearm during the commission of a felony, which was count 61, which is 5 years to serve consecutive to any count indictment. Possession of a machine gun, which was count 62, which was 10 years to serve consecutive. And then he was charged with count 63, which is possession of a firearm by convicted felon pursuant to 1611-133. I know my math isn't the best, but that's life plus some years. The state's recommendation, Your Honor, was for Mr. Kendrick to plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which was 20 to serve 15. Count 2, the murder reduced to voluntary manslaughter, 20 years to serve 15. And then to the gang count 57, also 20 years to serve 15, all to run concurrent, and the state was willing to null pros all the other counts in the indictment.
All right. And Mr. Kendrick and the attorneys associated with you, I want to make sure that y'all know that unlike what happened with Mr. Williams, if you plead non-negotiated to less than all of the charges, there is nothing that the court can do if the state chooses to go forward with some of those charges. So you could not do what Mr. Williams pled guilty or nolo to each of the charges that he was facing. You cannot say, well, I'd like to plead guilty to count 1 and I'd like to plead to the reduced charge on count 2, and then I'd like to just skip the rest of them, because the state can say, well, we're not skipping the rest of them, we're still going to try you for the rest of them. And the state can also say, we're not okay with letting you plead to voluntary manslaughter unless you abide by the terms of the agreement. We're going to go forward with the murder trial. So I know that Mr. Weinstein, you and Mr. Apt and everybody else who's been helping know that, but because things seem to have worked out sort of beneficially for some of these other people who have already pled, y'all might think, oh, well, gosh, can't we do something better than that? Given what you're facing, they hold a lot of the cards, and a lot of it is outside of the ability of this court to change, okay? All right.
We understand that, Your Honor. Thank you for advising us of that.
All right, Mr. Stillwell is facing...
Your Honor, Mr. Stillwell is also looking at count 1, which is the conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which is 5 to 20 years. He is facing 2 counts of murder for count 2 and count 49, which each carries a sentence of life imprisonment. He's also charged with count 50 of this indictment, Your Honor, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's also charged with count 51, participation in criminal street gang activity, also a sentence of 5 to 20 years. Count 52, possession of a firearm by a convicted felon, previously convicted under 1611-133, which is 15 years consecutive to any count in the indictment. 54, possession of a firearm during the commission of a felony, which is 5 years to serve consecutive. Count 64, which is another possession of a firearm by a convicted felon under 1611-133, which is also 15 years to serve consecutive. So Mr. Stillwell's looking at maximum of 2 life sentences plus
85 years.
Plus 85 years, Your Honor. The state's recommendation, and I'll just say globally, Your Honor, was 60 years to serve 40 years in prison. That we would have reduced both of the murders to voluntary manslaughter, Your Honor, and we had given his attorney the option to kind of craft how that 40 years would look, but that was the extent to our negotiations, Your Honor.
And Mr. Stillwell, kind of the same information to you. If the state does not want to reduce charges, you're not entitled to plead to reduce charges. They can say, you got to face these murder charges and we're going to make it a jury trial if you don't agree to what we're offering. Same thing, you can't say, well, I'd like those other charges dismissed if they're not willing to dismiss them in exchange for the negotiated sentence. So obviously each of you has the right to continue with the trial. You know, what you're doing, you are all have very capable attorneys representing you, who clearly care very passionately about you all personally, as well as presenting your best case. But it's ultimately going to be up to the jury, and you cannot know what any jury is going to do. And they may say, I don't believe a single bit of this beyond a reasonable doubt. Y'all are both walking. They may say, you know what, I buy this, I don't buy that. I'm convicting you of 4 of the 5 or 4 of the 8 charges. You're still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40 years to serve with parole as a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years instead of 20 to serve 15. So it's just something to think about. And I mean, it's already past 5 o'clock. So are y'all going to leave the offer open until you have withdrawn the offer before you even put it on the record to?
We communicated this to them last night, but they did not accept it. That we would have withdrawn the offer.
All right, well, given that the state spent the entire day negotiating Mr. Williams' plea, ultimately unsuccessfully, I don't know if either Mr. Weinstein or Mr. Sharp would have been able to negotiate with you during today.
They would have, we didn't have any communication from Mr. Weinstein or Mr. And they rejected the offer.
Okay.
You on some dirty shit, man.
I did have
knew that was
communications with Mr. Abate today. I attempted to have communications with the DA last Tuesday morning, but she failed to show up for our meeting.
Any chance y'all might leave it open until 9 o'clock tomorrow?
Your Honor, I'll consult with the DA, and if she wishes to read.
Okay. I mean, I have no idea whether they'd want to keep it, but I haven't, we haven't put it on the record, and I haven't ensured myself as the court that they understood what the potential sentences were up until just now. So I would appreciate it if she would, so that they have the opportunity, having heard from the court, to talk to their attorneys. And they may still say that we're good, we're going forward, but.
We'll consult with the district attorney, but as a.
Okay. So in the event that it is no longer open to you, or that you decide to reject it anyway, I plan to start the trial again Monday morning. I'm going to have the jury be here at 9. I'm going to have us be here at 8:30. We're back to getting no sleep. So I'll see y'all at 8:30 regardless. Okay, now court is adjourned.
That's some crazy shit right there.
This is the Unbeatable Boss.
That evidence would have been presented. It wouldn't have existed.
That evidence right there that you talking about didn't make it to court. The last one. The first one did, but it don't got no merit. Because nobody really wasn't getting stepped on, bro. And even the judge said, well, no, ho, still said that. Like, bro, dudes was getting threatened, alleged, There wasn't nothing happening. That's just the same thing with like, yo, they alleged that these boys was an official blood crew. But everybody know that somebody is ratting, but ain't nobody getting no licks about that. And I'm going to keep it real. If you look at other paperwork, gangs is not playing about rats, especially not with paperwork on them. I swear to God. If you read some of these other goddamn indictments, niggas, these gangs not playing about no goddamn ratting on paperwork, y'all. I'm going to keep it real.
How long you think he gonna last on paper, man?
He gonna breathe, bro. He gonna breathe. Nah, he got that. He got that, bro. Nah, bro, niggas with money is above the law. Honestly, like in this scale, like staying out of trouble type shit, hell yeah, he good. Hell yeah. Nah, bro, he good, bro. He ain't, all you gotta do is not put yourself in regular people environments. Everywhere else, you kind of protected. Real rap. Especially in this situation now, hell yeah, yo gonna be, you feel me? He gonna be. First off, the box gonna keep him safe.
15 years, bro.
Nah, he ain't that type of lifestyle not regular though. Yeah, he coming home.
You been said that, bro. Like day 40, bro. Probation is made for you to fuck up. Like,
fact.
Look at that me shit. This dude doing a fucking cartwheel. How the fuck he get violated? Like, come on, man. This shit. You know how it goes.
Hey, I give you that.
How long you doing on probation?
Nah, he only got to do 10 y'all solid, and the rest get knocked down. Don't sleep.
Yeah, if you do good. But that shit hard, boy.
Hell no, it's hard for a nigga that's walking through the trenches every day that's, in the middle trying to make a play. If you don't need to bust no move, you can mind your business, fuck bitches, play with your kids, and eat some food, man. Just like you locked up.
Don't even do no moving. Yeah, he good.
Like, come on, bro. Go get some more money. Go be a part of, like, nah, bro. Nah, this ain't the same as a regular person. Let's put a little bit of division in between this probation, the way this plays out. If you still gotta go day to day in and out the trenches, like on some more, you staying in with your peoples or you got your own spot and you just regular in Atlanta, yeah, you can easily get put in a situation.
But guess what? But guess what about to happen? Still them did their homework. Whatever state he go to, whatever probation system he going to, he gonna be good.
He gonna be good.
If he go to Cali, all he do is you gonna be able to get your scripts.
Yo, I can keep you out of trouble.
You right.
I ain't gonna lie. There's money on the line. Me alone. I'm talking about no security. The shit I'm gonna say to you gonna get your mind right. Straight like that. I'm your engineer and your videographer. I ain't letting you. Just straight. We ready to do so much shit that's right. Letting some bullshit come around, you feel me? Like I even got you on some old, you ain't even popping pills or none of that in front of people. Nobody ain't even gonna get to the open eye. We gonna be able to tell people that you don't even get high no more. That's how tight we ready to run this.
And then I think and y'all know how that county time is. I know that shit killed him. For even Rick, you can't go outside. I got light skin in that motherfucker, so you can't even go to Rick with him.
Attorneys were going to represent you through either the last day of this term of court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things.
No, I think he just got. I think he was just trying to get the load in. I don't think he was trying to major move. I think Holmes was trying to get the load in, make sure everybody's straight so he could be straight. I don't think Holmes was trying to turn it into a show enough operation. I think niggas was trying to make the pack land. Yeah, that's the best move.
Everything you said, bro. I've been watching from day one. Everything you ever said, that shit true. All this shit is behind getting that brand new jail, Fannie Willis.
I think that's the main thing right there, y'all.
That shit with Trump under the table. They ain't even fuck with Trump.
I'm gonna keep it real. I think that was the play. I think the play been in for them to move this way. And it just happened to be they needed this type of thing to shine light on these gangs to get the real ball rolling for the real show. Straight up, y'all. And I believe
you just like me, E. I always was scared of Atlanta, bro, because I look at that shit and I be like, damn, you just scared. That shit real when you come from the real trenches. I'm from New Orleans. When you come from the real trenches, shit like that, like big meats, how they would move, all that shit just scary to me.
Hell yeah, like, man, that's cat. The boy's hot.
We're trying to hide this shit that we not doing.
Hey, you ever seen this shit before? I ain't never seen no shit like this in my life. Pay attention.
Read all that shit.
You know?
Here in Ohio, our family businesses are using crypto and blockchain to stay competitive and to protect the jobs in our community.
Hey, I'm gonna show you what's crazy. Yeah, they gonna get that shit in the body that called smart attention to that.
That's why I'm a crypto voter. Don't let anyone else decide your future. Make a plan to vote.
This is The Wire for 2300 Zulu, October 29th, 2024. Precedence is routine. Information cutoff is 2200. Bottom line up front. Russia conducts large-scale nuclear weapons drill. Widespread election integrity issues continue throughout the United States. Beginning with international events, in Russia, this morning a large-scale test of Russian nuclear capabilities was conducted, with test launches from the sea, land, and air taking place simultaneously. An RS-24 Yars ICBM was test-launched from the Plesetsk Cosmodrome, along with unidentified cruise missiles test-launched from strategic bombers. 2 different submarine-launched ICBM tests were conducted as well. On the home front, in the United States, election irregularities continue to grow nationwide. In Pennsylvania, prospective voters reported that at least one early voting polling place in Bucks County closed several hours early today. Also in Bucks County, unknown personnel have been observed using fake or deceptive badges, pretending to be poll workers or election officials, allegedly telling people to go home and that they cannot vote at particular voting sites. Analysts comment. Per Pennsylvania law and the laws of most other states, polling places must remain open if there are voters in line to vote. No one can tell any citizen to go home for the day or try again when it's not too crowded. If you are in line when the polling place closes, you have the right to cast your ballot. In Lancaster County, Pennsylvania, the Board of Elections released a statement that approximately 2,500 voter registration applications are being investigated for fraud. These applications were dropped off at the elections office in 2 large batches a few days ago, all of which allegedly had the same handwriting patterns. In Fresno, California, a ballot Dropbox key was found to be left in the lock at a Dropbox by a voter dropping off their ballot, prompting security concerns. In Lane County, Oregon, a key to at least 2 USPS mail drop boxes was stolen, prompting authorities to urge voters who may have dropped off their mail-in ballots in the affected boxes to track their ballots online. In Georgia, this afternoon, an active shooter was reported at the Four Seasons Hotel in Atlanta. An unidentified man was observed to be randomly shooting from a balcony at the hotel. Analysts comment. Though details are challenging to confirm, this was possibly more of a mental health crisis than a more calculated sniper attack. However, as the assailant's position offered line of sight to significant portions of downtown Atlanta, locals were urged to shelter in place while the crisis was ongoing. After a few hours, authorities gave the all clear after the suspect was in police custody. Analyst comments for this wire. While comparatively rare to see a simultaneous combined arms test of Russia's nuclear triad, this likely follows the readiness drills that took place earlier this month, with the tests being a more deliberate live-fire test of various missile platforms. The timing of these ICBM tests is also likely intended to serve as a more direct message to the United States during a time of heightened tensions domestically. This concludes the wire for 2300 Zulu, October 29th, 2024.
Well, good
bacteria, either in film preparations or in cultures, that could account for the disease. And since among our long series of propagations of the virus in monkeys, not one animal showed in the lesions the cocci described by some previous investigators, and we had failed to obtain any such bacteria from the human material studied by us, we felt that they could be excluded from consideration. What they then did was to make a bizarre supposition, a leap of faith, not a scientific claim. They took their hypothesis of viral exogenous agency and made it fact with no proof whatsoever. They asserted, therefore, the infecting agent of epidemic poliomyelitis belongs to the class of the minute and filtrable viruses that have not thus far been demonstrated with certainty under the microscope. Simon Flexner simply asserted it must be a poliovirus killing the monkeys because they could find no other explanation. In fact, he did not look for another source of the illnesses. This was not scientific isolation. It was wild speculation that have not thus far been demonstrated with certainty under the microscope. They admitted this in a December 18, 1909 follow-up in JAMA titled The Nature of the Virus of Epidemic Poliomyelitis. The so-called virus they were injecting into monkeys was hardly pure. It also contained an undetermined amount of contaminants. It included pureed spinal cord, brain, fecal matter. Even flies were ground up and injected into monkeys to induce paralysis. Until Jonas Salk won approval from the US government in April 1955 for a polio vaccine, no scientific proof of existence of a virus causing poliomyelitis or infantile paralysis, as it was commonly known, had been proven. That is the case to this day. The medical world all took Flexner's word that it must be a virus. Rockefeller Institute, Flexner, and the American Medical Association. The Rockefeller Institute was founded from the Standard Oil fortune of John D. Rockefeller in 1901 to be America's first biomedical institute. It was modelled on France's Pasteur Institute, 1888, and Germany's Robert Koch Institute, 1891. Its first director, Simon Flexner, played a pivotal and most criminal role in the evolution of what became approved American medical practice. The Rockefeller goal was to completely control American medical practice and transform it into an instrument, at least initially, for promotion of medical drugs approved by the Rockefeller interests. By then they were looking to monopolize medical drugs produced from their petroleum refining, as they had done with oil. As Rockefeller Institute head Simon Flexner was publishing his inconclusive but highly acclaimed studies on polio, he arranged for his brother, Abraham Flexner, a schoolteacher with no medical background, to head a joint study by the American Medical Association, the Rockefeller General Education Board, and the Carnegie Foundation, funded by Rockefeller's close friend, Andrew Carnegie. The 1910 study was titled The Flexner Report, and its purpose was to investigate the quality of all US medical schools. The outcome of the report was, however, predetermined. Ties between the well-endowed Rockefeller Institute and the AMA went through the corrupt AMA head, George H. Simmons. Simmons was also the editor of the influential Journal of the American Medical Association, a publication delivered to some 80,000 doctors across America. He reportedly wielded absolute power over the Doctors Association. He controlled the rising ad revenues for drug companies to promote their drugs to AMA doctors in his journal, a highly lucrative business. He was a key part of the Rockefeller medical coup that was to completely redefine acceptable medical practice away from remedial or preventative treatment to use of often deadly drugs and expensive surgeries. As head of the AMA, Simmons realized that the competition from a proliferation of medical schools, including then recognized chiropractic, osteopathy, homeopathy, and natural medicine, was lessening income of his AMA doctors, as the number of medical schools had increased from around 90 in 1880 to over 150 in 1903. Abraham Flexner, former headmaster of a private school, toured various U.S. medical schools in 1909 and recommended that fully half of the 165 medical schools be closed as what he defined as substandard. This reduced competition from other approaches to healing diseases. They ruthlessly targeted then widespread naturopathic medical schools, chiropractic ones, osteopaths, as well as independent allopathic schools unwilling to join the AMA regime. Then Rockefeller money went to the select schools with a proviso that professors be vetted by the Rockefeller Institute and the curriculum focus on drugs and surgery as treatment, not prevention, nor nutrition, nor toxicology as possible causes and solutions. They had to accept Pasteur's germ theory of disease, which claims one germ to one disease reductionism. Rockefeller-controlled media launched a coordinated witch hunt against all forms of alternative medicine, herbal remedies, natural vitamins, and chiropractic. Anything not controlled by Rockefeller-patented drugs. By 1919, the Rockefeller General Education Board and the Rockefeller Foundation had paid out more than $5 million to Johns Hopkins, Yale, and Washington University and St. Louis medical schools. In 1919, John D. Rockefeller granted another $20 million in securities for the advancement of medical education in the United States. That would be comparable to about $340 million today, a huge sum. In short, the Rockefeller money interests had hijacked American medical education and medical research by the 1920s. Creating virology. This medical takeover, backed by the most influential doctors' organization, the AMA, and its corrupt head, Simmons, allowed Simon Flexner to literally create modern virology under Rockefeller rules. The highly controversial Thomas Milton Rivers, as director of the Rockefeller Institute's virology laboratory, established virology as an independent field, separate from bacteriology during the 1920s. They realized they could manipulate far easier when they could claim deadly pathogens that were invisible germs or viruses. Ironically, virus comes from Latin for poison. Virology, a reductionist medical fraud, was a creation of the Rockefeller medical cabal. That highly important fact is buried in the annals of medicine today. Diseases such as smallpox or measles or poliomyelitis were declared caused by invisible pathogens, called specific viruses. If scientists could isolate the invisible virus, theoretically they could find vaccines to protect people from harm. So their theory went. It was a huge boon for the Rockefeller cartel of pharmaceutical companies, which at the time included American Home Products, which falsely promoted drugs with no proof of effect, such as Preparation H for hemorrhoids or Advil for pain relief, Sterling Drug, which took over the US assets, including aspirin of German Bayer AG after World War I, Winthrop Chemical, American Cyanamid, and its subsidiary Lederle Laboratories, Squibb, and Monsanto. Soon virus researchers at the Rockefeller Institute, in addition to claiming discovery of the poliomyelitis virus, claimed to discover the viruses that caused smallpox, mumps, measles, and yellow fever. Then they announced discovery of preventative vaccines for pneumonia and yellow fever. All of these discoveries announced by the Institute proved false. With the control of the research in the new area of virology, the Rockefeller Institute, in collusion with Simmons at AMA and his equally corrupt successor, Morris Fishbein, could promote new patented vaccines or drug remedies in the influential AMA journal that went to every member doctor in America. Drug companies refusing to pay for ads in the AMA journal were blackballed by the AMA, controlling polio research. Simon Flexner and the highly influential Rockefeller Institute succeeded in 1911 in having the symptoms that were being called poliomyelitis to be entered into the US public health law as a contagious infectious disease caused by an airborne virus. Yet even they admitted they had not proven how the disease enters the body of humans. As one experienced doctor pointed out in a medical journal in 1911, our present knowledge of the possible methods of contagion is based almost entirely upon the work done in the city at the Rockefeller Institute. In 1951, Dr. Ralph Scobie, a critic of the Rockefeller rush to judgment on polio contagion, noted, "This of course placed reliance on animal experiments rather than on clinical investigations." Scobie also pointed to the lack of proof poliomyelitis was contagious. Children afflicted with the disease were kept in general hospital wards, and that not a single one of the other inmates of the wards of the hospital was affected with the disease. The general attitude at that time was summed up in 1911. It seems to us, despite the lack of absolute proof, that the best interests of the community would be conserved by our regarding the disease from a contagious standpoint. By having poliomyelitis symptoms classified as a highly contagious disease caused by an invisible alleged exogenous or external virus, the Rockefeller Institute and the AMA were able to cut off any serious research for alternative explanations, such as exposure to chemical pesticides or other toxins, to explain the seasonal outbreaks of illness and paralysis, even death, mostly in very young children. That was to have fatal consequences lasting to the present. Enter DDT. In his 1952 statement to the US House of Representatives, investigating the possible dangers of chemicals in food products, Ralph R. Scobie, MD, noted, "For almost half a century, poliomyelitis investigations have been directed towards a supposed exogenous virus that enters the human body to cause the disease. The manner in which the public health law is now stated imposes only this type of investigation. No intensive studies have been made, on the other hand, to determine whether or not the so-called virus of poliomyelitis is an autochthonous chemical substance that does not enter the human body at all, but simply results from an exogenous factor or factors, for example, a food poison. Toxins as cause were not investigated despite huge evidence. During the 1930s, with economic depression and then war, few new major outbreaks of poliomyelitis were noted. However, immediately after the end of World War II, notably the polio drama exploded in dimension. Beginning 1945, every summer, more and more children across America were diagnosed with poliomyelitis and hospitalized. Less than 1% of the cases were actually tested via blood or urine tests. Some 99% were diagnosed by merely the presence of symptoms, such as acute pain in extremities, fever, upset stomach, diarrhea. In 1938, with the support of presumed polio victim Franklin D. Roosevelt, the National Foundation for Infantile Paralysis, March of Dimes, was founded to solicit tax-exempt donations to fund polio research. As presumed cases of polio literally exploded across the USA after 1945, the theory was advanced with no proof that the crippling polio disease was transmitted not by toxic pesticide chemicals like DDT, but by mosquitoes or flies to humans, most especially young children or infants. The message was that DDT can safely protect your family from the crippling polio. Officially, listed polio cases went from some 25,000 in 1943 before US civilian use of DDT to over 280,000 cases in 1952 at the peak, more than a tenfold increase. In October 1945, DDT, which had been used by the US Army under supervision of Rockefeller Institute's Henry Coombe, as noted, was authorized by the US government for general use as an insecticide against mosquitoes and flies. Dissenting scientists warning of toxic effects of DDT in humans and animals were silenced. Families were told DDT could save their children from the dreaded polio by killing the feared insects. The US Department of Agriculture advised farmers to wash their dairy cows with a solution of DDT to combat mosquitoes and flies. Cornfields were aerial sprayed with DDT as well as fruit orchards. However, it was incredibly persistent, and its toxic effects on plants and vegetables were such it could not be washed off. Year by year, from 1945 through 1952, the amount of DDT sprayed across the US increased. Notably, so too did the number of human cases of poliomyelitis. Worst polio epidemic. By the beginning of the 1950s, increasing attention was given in the US Congress and among farmers as to the possible dangers of such heavy pesticide use, not only DDT, but also the even more toxic BHC, benzene hexachloride. In 1951, Morton Biskind, a physician who had successfully treated several hundred patients with DDT poisoning, testified to the US House of Representatives on the possible link of paralytic polio to toxins, specifically DDT and BHC. He noted, "The introduction for uncontrolled general use by the public of the insecticide DDT and the series of even more deadly substances that followed has no previous counterpart in history. Beyond question, no other substance known to man was ever before developed so rapidly and spread indiscriminately over so large a portion of the earth in so short a time. This is the more surprising as at the time DDT was released for public use, a large amount of data was already available in the medical literature showing that this agent was extremely toxic for many different species of animals, that it was cumulatively stored in the body fat, and that it appeared in the milk. At this time, a few cases of DDT poisoning in human beings had also been reported. These observations were almost completely ignored or misinterpreted." Biskind further testified to Congress in late 1950. "Early last year, I published a series of observations on DDT poisoning in man. Since shortly after the last war, a large number of cases had been observed by physicians all over the country in which a group of symptoms occurred, the most prominent feature of which was gastroenteritis, persistently recurrent nervous symptoms, and extreme muscular weakness." He described several case examples of patients whose severe symptoms, including paralysis, disappeared when exposure to DDT and related toxins was eliminated. "My original experience on more than 200 cases, which I reported early last year, has since been considerably extended. My subsequent observations have not only confirmed the view that DDT is responsible for a great deal of otherwise inexplicable human disability. Also noted was the fact that polio cases were always most in summer months, when DDT spraying against insects was maximum." The Rockefeller Institute operatives and the AMA, via their agents in the US government, created the 1946 to 1952 US health emergency called polio. They did so by knowingly promoting the highly toxic DDT as a safe way to control the mythical insect spreaders of the feared disease. Their propaganda campaign convinced the American population that DDT was the key to stop spread of poliomyelitis. Polio suddenly declines. Under leadership of the two Rockefeller Institute doctors, Henry Coombe and Thomas Rivers, the National Foundation for Infantile Paralysis rejected critics such as Biskind and Scobie. Natural remedial treatments such as using intravenous vitamin C for the infantile paralysis were rejected out of hand as quackery. In April 1953, leading Rockefeller Institute DDT consultant Dr. Henry Coombe became Director of Polio Research for NFIP. He funded the polio vaccine research of Jonas Salk. One courageous doctor in North Carolina, Dr. Fred R. Klenner, who had also studied chemistry and physiology, had the idea to use large doses of intravenous ascorbic acid, vitamin C, on the hypothesis that his patients were victims of toxin poisoning and that vitamin C was a powerful detox. This was well before Dr. Linus Pauling's Nobel Prize research on vitamin C. Klenner had remarkable success within days for more than 200 patients in the summer epidemics of 1949 to 1951. The Rockefeller Institute and the AMA had no interest in the remedial prospects. They and the Rockefeller-controlled National Foundation for Infantile Paralysis were only funding polio vaccine development based on the unproven Flexner claim that polio was a contagious virus, not a result of environmental poisons. Then, beginning sometime in 1951 to 1952, as polio cases were at an all-time high, something unexpected began to appear. The number of cases diagnosed as polio in the US began to decline. The decline in polio victims was dramatic, year by year until 1955, well before the National Foundation and Jonas Salk's polio vaccine was approved for public use and was widespread. About a year before the sudden decline in polio cases, farmers whose dairy cows were suffering severe effects of the DDT were advised by the US Department of Agriculture to reduce DDT use. Rising public concern about how safe DDT was for humans, including publicized US Senate hearings on DDT and polio in 1951, also led to a significant decline in DDT exposure into 1955, even though DDT was not officially banned in the US until 1972. So-called polio cases fell by some 2/3 in that time, in a remarkable parallel to the decline in DDT use. It was well after that decline in late 1955 and 1956 that the Rockefeller-developed Salk polio vaccine was first administered in large populations. Salk and the AMA gave all credit to the vaccine. Deaths and paralysis as a result of the Salk vaccine were papered over. The government changed the definition of polio to further reduce official cases. Simultaneously, cases of similar polio-like spinal cord nerve diseases, acute flaccid paralysis, chronic fatigue syndrome, encephalitis, meningitis, Guillain-Barré syndrome, and multiple sclerosis rose notably. Why it matters. Over a century ago, the world's richest man, oil baron John D. Rockefeller, and his circle of advisors set about to completely reorganize how medicine was practiced in the USA and the rest of the world. The role of the Rockefeller Institute and figures like Simon Flexner literally oversaw the invention of a colossal medical fraud around claims that an invisible contagious extraneous germ, the poliovirus, caused acute paralysis and even death in young people. They politically banned any efforts to link the disease to toxin poisoning, whether from DDT or arsenic pesticides or even contaminated vaccine poisoning. Their criminal project included intimate cooperation with the leadership of the AMA and control of the emerging drug industry, as well as of medical education. The same Rockefeller Group financed Nazi eugenics at the Kaiser Wilhelm Institutes in Germany in the 1930s, as well as the American Eugenics Society. In the 1970s, they financed the creation of patented GMO seeds, which were all developed by the group of Rockefeller chemical pesticide companies, Monsanto, DuPont,